like the wrong person to say that to.
It shouldn't be too bad, I don't think.
Okay. Yeah, it's not too bad. I'm gonna get some parts out of my vehicle though, because the last couple ones, yeah.
No, Sterling can't make this one. I don't think. It's me and Dexter that are subpoenaed. Everyone else is on the witness list. What'd you say, Queen?
Oh, did they finish River's car?
Yeah, I think so.
Yeah, I was like deep in my head.
Okay, what's weird is like I got that email.
Oh, hey, I'm ready. Ready to fight some crime.
Oh, I thought you were going to court.
I am. I'm fighting crime in court.
Oh, you prosecuting this one?
I am.
Lock him up.
Well, this will be interesting. Interesting case to argue today.
What's your over under on your chances?
I think
Rivers-
80-20.
Yo.
Oh, that's good odds.
Why does your hair look
Hey,
like
Rivers.
emo boy?
I don't know.
He's starting a
Hey,
K-pop career.
KP, I want your opinion. What's your opinion on pretrial diversions?
I have a more pressing question. What's up with your hair?
No.
That's
What do you think, KP?
Well,
Wants to be your little
they can
soda
only
pop.
be presented by the Department of Justice.
Yeah.
I think they're good for first-time offenders, people without a repeat criminal history. Minor offenses, I don't think you should be getting a pretrial diversion for attempting to murder somebody. Oops. Pretrial diversion, no. I think it's good for minor offenses, first-time offenders.
All right, sounds good.
Why's that?
I got DOJ upsetty because I said that I think they're kind of a waste of PD resources. Where's my car?
Maddie parked it.
Oh, she's great.
It all depends on the circumstances.
It's more so the guy didn't really have much of an answer, you know? I asked him, like, why were you speeding? And he's like, oh, I was just lost in the sauce, you know?
Oh, that guy.
Yeah, what, you've already heard of this?
I was in the sales.
Oh, yeah.
The Parks employee lost in the sauce, felony speeding.
Yeah, well, no, it was misdemeanor speeding.
Well, in a commercial vehicle.
Yeah.
Power
I
slide.
guess I upset some people with my response, that's all.
Well, it's kind of like,
Night, night.
especially in regards to speeding, it's kind of along the lines of that stupid law we had where they get one chance at felony speeding and they don't get charged, they get a freebie. Which was
Did you hear
stupid.
me yawning, Storm? So he said
I agree, I can't believe that ever passed.
That's why I said night.
Yeah. Let me go check on
But
my
alright.
car.
Bye.
Good as new.
Good as new.
Oh my god, I'm so excited. Thank you so much.
Yeah, not a problem.
I'm gonna park it.
Yep.
Alright, let's make our way. I'll go code 2. Why not? I don't don't know how people enter into here. Where they come from. We'll park this across the street and park it in the garage. The hell is this truck?
Yeah, that's Kelly Price.
Yeah, that's her.
Oh my god,
Hello.
hey. What's up?
Hello. Evening.
Hello.
Just vibing out.
Just vibing.
Yeah.
Somebody delivering cars.
I couldn't figure out what to drive.
So you drove a
So I
truck with a
brought,
bunch
like,
of...
a couple cars, right, to like be fashionable. I wasn't sure, you know.
Oh.
Yeah, you step out and all the paparazzi are like, pew 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 pew.
Mans couldn't decide, so you picked all of them.
I arrived a little bit too early, so there was no paparazzi at the time, unfortunately. But hey, at least isn't like a tanker, right?
I suppose.
Who the hell is that? Parking like a maniac.
Has the semi truck just been here, by the way?
It's Draz's.
Yeah, it's driving.
Well, it's not mine. It's a rental.
There's Vance with his suit. I'm glad he has pants on this time.
Is he in like a skirt?
Was he
last
not
time?
wearing
A
pants
kilt?
last?
Yeah, last time there was no pants.
Unfortunately, I was in that courtroom for that, I believe.
Uh-huh.
Oh, then the blue people arrived. Cool, cool, cool. We're all here.
Well, they're not.
This is
blue people.
Marcus Ward's, not Cameron's, right?
Yeah.
Okay.
Cameron's tomorrow, which I don't get why we're doing this, but you know.
Yeah, so if
So
you
that
don't
we're
get to
not in
see the
court for
court
50
case
hours.
today, you can see it tomorrow.
Yeah.
Yeah.
No,
Got the
it's
40
like
on tap.
we made it, you know, convenient for everyone in the state. If you don't feel like being around this late, you can just be around earlier tomorrow, and you will see the exact same
Oh.
court case.
I need to go through the questions in, I guess all the ones that don't relate to Marcus Ward. I'm trying to go through and note what line the evidence is on, but... anything that's not related to Marcus Ward, I'm just highlighting in yellow.
That's good. Well, we have time. We have like another 15 minutes plus pre-trial plus opening. So
Wonder how quickly they'll start letting people inside.
I'm gonna go in so I can be at the front of the line.
I mean, probably already go in. The bailiff is there.
Yeah, probably.
What kind of parking is that?
Huh?
I'm
Judging.
literally just-
Judging.
No, 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 no.
No. You've been here 30 minutes.
In here.
This is the court case.
Yeah.
Oh, counsel's entering without being searched.
She is a cop.
Not to let people. Oh, hi. Oh, Jesus.
Oh, excuse me. Hello.
Kelly, it's been a while.
It has. I've been incredibly, such a busy person.
We're gonna have another person around, thankfully. So nice.
So containers, whatnot, they can have it.
Okay.
Proceed.
All right.
Cool. You're welcome.
All right. Yeah, I don't think that's what I'm saying. Like, I don't think they'll. Hopefully, they won't cause an issue, but you know, it's at 4K is the issue. I assume. All right. All right.
Appreciate you. Thank you.
Yeah, appreciate you.
Mm. $24 A through $24 E.
Finally, someone picked this courtroom.
31.
Oh. I'm not used to being on this.
Where did I put them?
I know. It sounded like it to me.
Let me see. Where did I put them? No. Here. Let me look at the docket. What is this? Oh no. This is Marcus Ward. God damn it. Alright, Marcus Ward. 4A.
Hello.
24.
I can speak from experience. He really does suck.
He tried to fight me in the prison.
And Wait. $22.
Yo, they were busy in there, Matt.
Kelly, who are you call? Kelly, come here.
Don't talk to
Dude,
your
let
wife
me,
like that.
Or DOJ.
What's up?
What order are you doing this?
Well, who do we have? We got you
me-
and Diaz. Hopefully Graver.
Is Graver
Said he
supposed
would
Also,
to be
I'm
here?
good. I'm
Kelly,
good,
you're
KP. If you want to call Dexter before
She's
me, you
always
can.
around.
I'm good.
Yeah, Kelly, you're yelling.
I'm here now, so may as well see it through.
Where is
Alright,
Logan
perfect.
Graver?
Is that April
I'm gonna call
Storm?
him.
Yes,
Look at all
That
that
is
ma'am.
white.
April
I
Storm.
feel like I should have
Mr.
worn
Graver,
white.
are you supposed to be at court? Where are you?
Yes, he's supposed to be at court. Tell him to get here.
Perfect. Perfect. Okay, just double checking.
Probably
Yeah.
I'm going to call me first, and then I can
Oh, you just
call
leave it out there and lock it.
Layla.
Yeah,
And then Cutter.
Okay.
So I'm not going to
Perfect, see you
submit
soon.
your affidavit.
Bye.
I'll
Okay,
probably
Graver's
submit
walking
Storm's affidavit though.
That's fine with me.
Sterling.
You are yelling, apparently.
I came from moral support.
Oh, that's fine. I didn't say anything important. Just what affidavits we're going to submit.
Oh,
So
okay.
22A and B on line 24 and 22C and D on line 31.
I'm sick. You don't want that. So if I'm needed, I'll be here. If not, that's cool. Because I'll probably have to cut out.
I'm here.
At like
Don't kill me.
Perfect. It was my wife
8:30,
asking
9 o'clock.
for you. And when my wife says, find out, I go, yes, ma'am.
Mm-hmm.
Yeah, KP, you should have wore white. What the heck?
I know, dang it. It's too late. I look
She
good
was
in
thinking
black.
about it.
You look good. Never mind.
I
Let's
know
save
how
that
I
for
look
home.
best. It's fine.
Hey, he lifted it. You look good. We all look good. We
I
all
was gonna
slaying.
say some. I was gonna say
No,
some stuff,
no,
and then
let's
decided not
just
to.
leave it
Nope,
there.
no.
I know. That's why I did it.
We're just gonna leave it
I'm
right
so proud
there.
of you right now.
Thank you so much. Come a long way after getting yelled at.
All right, so we need to object. We need to submit everything that is on hold.
Who's our judge, by the way?
Reginald Blackstone.
Never
Yeah,
heard of
that
him.
one.
Like an old British guy.
I don't necessarily think we need an opening statement, but if we do provide one, I would leave out the part that says, hey, we don't want to undo this court with a lengthy opening statement, but here's our opening statement. We can just start with the opening statement without that.
Yeah, I think that was like good.
So we want to assert our objection to those witnesses.
Mm-hmm. Well, they have to assert that they're calling the witnesses first again, and then we're raising an objection.
Oh, we're going to do that pre-trial.
Yeah, we want to worry about our evidence submission, and then if Murdank brings up his witnesses, we object to them.
Well, my only concern is it's outlined in the docket posting, line 32, that it needed to be brought up pre-trial. And I want to bring it up pre-trial. You know what I mean? Get ahead of it.
Yeah. It's 27 is his calling of witnesses, and then 31 and 33 is our evidence submission.
Hello.
Hi.
Are you guys ready to proceed?
Are we ready to proceed? I'm ready.
Yeah, sure.
Okay. Let me go just check on the magistrate real quick.
Yeah, and 27 is him calling the witnesses, so he has to bring up the witnesses again. Because it's his, as outlined by Reginald, it's his responsibility to bring up that motion. So I don't think he's going to forget about it, but you never know.
Okay, I like that. That's fair. So we're looking at 31. And
31 and
33.
33. The ballistics
It's
report of Logan Grove.
Oh,
The affidavits as well as ballistics report.
perfect. We can bring those up. They were submitted within the discovery period. I don't see why they
Sure.
shouldn't be accepted.
All rise. The court is now in session with the Honorable
Fine.
Magistrate Reginald Blackstone presiding.
Excitement. Court, yay.
Good evening, ladies and gentlemen. Please be seated. Court is now in session. Good evening, everyone. I am Magistrate Reginald Blackstone, presiding over this matter, bearing ref 2026 CM 050, the State of San Andreas against Marcus Ward. Before we get into this matter, I will state the rules of this court, so that way everyone knows the rule book that we're dealing with. So, firstly, all parties are expected to remain respectful at all times during these proceedings. When the court is issuing orders or directions, counsel is to be silent. The gallery is asked to remain as silent as the spirits which reside in the courthouse of the Capitol building. Please keep to only whispering so as to avoid any unintentional disruptions. I would ask that all persons do set their phones to silent or do not disturb. As I'm sure you may be a fan of your ringtone, the court may not find it to be quite the bop which you believe it to be. It is especially important for those persons in the front rows of the gallery to try to remain silent where they can. There is the chance that you can distract counsel, and I cannot imagine that they want to hear the latest Yeeter brisket during such an important hearing. Of course, disruptions of any kind from any person will be met with appropriate measures, including but not limited to obstruction of justice, contempt of court, failure to obey a lawful order, sanctions, or even a stern telling off and sent to bed without their supper. Now, this, to all the persons in the gallery, this is expected to be a rather long hearing. This is important to bear in mind. We will make best efforts, counsel, myself, and the witnesses, we will do our best to try and keep this moving at a steady pace. However, if you would like to leave, please be sure to do so at the earliest stage that you think you would need to. We don't want to have any claw marks on the inside of the courtroom doors. With that, we will move on to the Declaration of Representation. So for the state, who do we have, please?
Diana Frost, first chair, Your Honor.
Lieutenant Kelly Price Cutter, San Andreas State Police, second chair.
Thank you very much, counsel. And for the defense?
Your Honor, Matt Murdank of Hunt O'Hagan LLP, on behalf of Mr. Marcus Ward, who is present in court today.
Outstanding.
Good
and
for
if
him.
Mr. Ward could rise, the defendant rise and state his name just for the record, please.
I am Mr. Marcus Ward, and I am present in court today.
Thank you very much, Mr. Ward. Right, now, before we get into matters, I would ask counsel if we could have a brief sidebar. This is just so we can illustrate some important points before we start going into pretrial matters. So if we could come over here, please. As.
Your Honor, Mr. Ward wants to know if he can join us.
I'd prefer if he didn't, but he can if he. I'd rather if his attorney came in, just so we can focus on the same point.
That's fine. That's fine. He just wanted to ask.
No, I understand. So essentially, I do not want this to be a long hearing. You know, of course, I do imagine counsel do either, but it is one of these things that we're going to be keeping an eye on the clock here. There's not going to be any arbitrary time deadline or anything like that. We're not the type. I don't think we are the type to unnecessarily waste the court's time here at all. However, if the court does see, for example, witnesses, going on and on things like that, we will essentially step in if we see certain issues, for example, certain objections such as asked and answered not being observed. Then in that case, the court will step in once again to be able to make sure that we keep this going. We do not want to keep all these lovely people, the witnesses, the defendant, or counsel, here for any longer than we need to. Of course, we don't want hearings to be like pulling teeth. Of course, I would ask as well if counsel could ensure that the witnesses they've called stick to their scoping. If you do intend to go outside of that scope for whatever reason, please inform the court and request permission, with the opposing counsel being allowed to object. This is just so that we can keep exactly on time. Is that understood? Is there any issues with that at all?
No, Your Honor.
No.
No, Your Honor. I understand you don't want a 5-hour trial today.
Indeed, counsel. Yes. No, we try and keep it as I don't want to say brief, to be honest, but you know what I mean. Well observed on the
efficient.
Indeed. Yes, counsellor. Perfect. All right, excellent. In that case, we will move on to pre-trial matters. Thank you very much, counsel. Much appreciated.
Certainly.
Oh, Miss Frost, if I may, additional
Alrighty,
pre-trial
thank you
matter
very
is
much,
the inclusion of the
counsel, for
second
that brief sidebar.
lesser included charge.
Now we will now of course move into any pre-trial matters which are for discussion. My understanding is there are some on the docket, and my order, my most recent order was quite clear.
Well, the question is, do we want to include it or not?
So please, counsel, if you have anything in pre-trial.
It's up to you.
He did a massive objection on it on the camera and every sub, and I'd rather not fucking do it.
Your Honor, do you want to hear from the state first?
And we are feeling pretty confident about the matter.
We'll go for whichever party's ready. So
I didn't even look at it.
You're happy to go first.
All right. Well, let's just bring up the evidence exhibits then.
Your Honor, we would bring up matters from line 31 and line 33, the evidence submission of affidavits and ballistic report.
31 and 3. Any objection from defense counsel?
Your Honor, no objections to the evidence.
Lawless, thank you very much. So admitted. Any other pre-trial matters from the state?
I'll probably leave it. We're confident on first degree. If we're not getting it, we're not getting it.
Okay, fair enough. The state has nothing further.
Okay, alrighty, outstanding. Thank you very much. And defense counsel, do you have any pre-trial motions?
Yeah, Your Honor, I'd like to start with 2 motions, if that's all right, and then maybe more.
Of course, we'll see how we do.
The first motion is the first motion is a motion to dismiss as a matter of law, pursuant to 2025 AC 015, which is the Kingsman appeal, and 2026 CM 004. This court should find that as a matter of law, the state has not introduced evidence that would indicate that Mr. Ward engaged in conduct that was deliberate, planned, and targeted. These are both prior findings that indeed Chief Justice Baker sat on for the appeal. And the appeal itself is binding because it is an appeal. So the court has an opportunity to determine, even prior to trial, based on the evidence presented, whether that evidence is sufficient to establish that there was any modicum of this offense being deliberate, planned, and targeted as alleged in the indictment.
Of course. Counsel, could you provide me with that citation one more time, please, just so I have that?
Yeah, 2025 AC 015 and 2026 CM 004. And if it would please the court, I would be happy to email it to both His Honor and to the state.
Oh, that would be most appreciated.
I would be happy to do that.
State, you'll have your opportunity to object as soon as the case law is in front of me, and yourselves, of course.
Oh, you pulled it up. Can you send it to me?
Yeah, the Logan Kingsman is the one I already sent. What was the 2026 case, Your Honor? Apologies.
It's CM 004, and I've just blasted it via Bluetooth to His Honor and Ms. Price, and I'm working on you now, Ms. Frost.
The website is still acting up, so it's going to be difficult to get that one if I'm not having it open already.
Oh, it's that bench trial that I mentioned why they
No,
want
it is.
Hazel
Is
Rossi.
it the Hazel Rossi?
Mm-hmm.
If everyone could confirm they have the cases, that would be tremendously helpful.
Yes, it is before the court. Thank you, Councillor.
Outstanding.
State, I presume that is in front of you, and you are just discussing matters.
Yes, Your Honor.
Of course. Yes, no.
Well, we request a couple minutes to review.
Is this a recess or?
Sure, I love
How long
recess.
do you think we need?
Of course.
Your Honor, before recess is...
Oh, yes.
Wait, before recess is declared, I would just like to draw everyone's attention to a citation that exists within the 2026 case. So there's a third case as well. It's 2024 CM261, and there's a link in there for everyone to easily access it.
Yeah, that's on line 4 for everyone's reference. Yes, thank you, Councillor.
Certainly. No objections to recess at this point.
Okay, thank you very much. Court is in recess for 5 minutes.
Oh, a whole 5 minutes.
Well, the Logan Kingsman, I would argue that it's like a different case entirely. I mean, to be honest, the argument should be that these cases are fundamentally different to what we're dealing with here today. And also the fact that there's more evidence to be gathered from testimony. It is not just material evidence that we have. We have witnesses to be called and testimony to give.
I know that the Hazel Rossi and Sam Guba case was a bench trial.
Mm-hmm. So the bench trial is just, it's not. The only thing that's binding is the ace. And I'll be honest with you, like, I guess he's not exactly doing a motion to dismiss, he's doing a, what's it called? The one where they, like, look at the docket and see it's like, either it's gonna get not guilty or we continue, like that kind of motion. I forgot what it's called. Yeah, but it's the completely discouraging, like, witness testimony and saying like we don't have enough evidence to prove that it's planned and deliberated. It's like, okay, when are we ever going to get a first degree murder then? Be really with.
I just get rid of the charge.
Yeah, might as well get rid of the charge then. If it's like, if we're never going to get a conviction on first degree murder because the burden for it is so fucking high, then what's the point of it? Yeah, I think that's going to be it.
Would you like to take charge?
Sure.
I believe in you.
She put on the docket LT. What is that?
All rise. Court is now back in session.
I'm your boss.
Good evening, everyone. Court is back in session. All right. Now, after that brief recess, hopefully, prosecution, you have a response prepared.
Yes, Your Honor. We would object to the motion to dismiss on the basis that these are different situations, and also on the fact that we are here today to hear witness testimony to further establish that the matter was planned and deliberate.
Okay, reasonable. Councillor Murdoch, any rebuttals?
Yeah, certainly, Your Honor. The motion is that the evidence asserted in the indictment are insufficient as a matter of law. While the testimony may further flesh out, what actually happened, there is an obligation of the state to file indictments and proceed with indictments at trial that contain at least a modicum of evidence that the offenses alleged were deliberate, planned, and targeted. All three of those prongs must be fully satisfied in order to proceed to trial, and it has to be in the indictment and on the docket. And Mr. Ward asserts that even if the court considers the evidence presented on the docket and the indictment, that as a matter of law, these charges should be dismissed.
And counsel for the prosecution will go for one last volley from you.
One moment, Your Honor.
If you want to stand by your argument, that's perfectly fine. But
I don't think I have anything else to argue, to be honest.
No, I don't think so either. I think everything is laid out. I mean, there's a limit to what you can include in an indictment.
Your Honor, if they're speaking, I can't hear them.
I imagine they're conferring, Councillor.
Oh, I'm sorry. I thought that was what.
Would you like to hear us confirm?
Yeah, I would argue. I would. Your Honor, I think we've made our argument.
Of course. So the court will take a moment here to distinguish the matter of 2025 AC015. The distinction that the court would make here is that this matter went entirely to trial. The matter which was appealed, which was 2024 CM326, the State of San Andreas against Logan Kingsman, that it went entirely to trial, and to essentially deprive the prosecution from the ability to prosecute the case in its entirety and for all facts to be heard would be an unreasonable burden. Pursuant to the provisions of the Speedy Trial and Bail Act 2024, the court has some concern with essentially placing too much of a burden on an indictment, essentially because they have that restriction of 48 hours. Some matters, an arrest is made on the scene, and to essentially make this a high burden as to essentially establish every single element of the offense would be a bit high. The requirement is that the indictment show probable cause. That's why we have a preliminary hearing for that purpose. And that is basically to establish that it is reasonable, essentially, to bring these charges to court.
That's well
the
stated.
court does find that it is reasonable to bring these, and there is probable cause to pursue these charges, and therefore the motion is overruled. Was there any
Your
other
Honor,
pre-trial motions?
Yeah, certainly. I have a question about your ruling. We're not asserting that there was no probable cause. We're asserting that even with all the evidence on the docket, that there's no basis in fact or law from the evidence presented. To be clear, we're not. Well, first of all, there was a 90-day statute of limitations for this, and he was arrested not on the scene, but actually shortly thereafter. About 24 hours to be specific. So, I mean, they could have taken time to file an indictment, but nevertheless, like I understand His Honor's point. The point that I'm making is that there is a docket full of evidence here, and that evidence still does not establish, as a matter of law, that there is any evidence whatsoever that Mr. Ward engaged in conduct that was deliberate, planned, and targeted. So I'm asking for a ruling from His Honor about whether, as a matter of law, all of the evidence on the docket establishes any modicum of that these alleged acts were deliberate, planned, and targeted. And I would ask His Honor to say how that is the case if His Honor finds that it is.
The court won't be going into those details, to be honest. The court finds the indictment to be more than reasonable in these circumstances, and there is established. Well, they may not establish every element in the offence in the indictment, but that is why we have a full trial, Councillor. It is for this exact purpose
that's fine,
we
Your
have a full trial. So we maintain that the motion is overruled. Another pre-trial motion, I believe you did.
Yes. I have a second motion. This motion is also a motion to dismiss for violation of the Speedy Trial Act. This indictment was filed on, I believe, March 17th at 8:45 p.m. Eastern Time. The Speedy Trial Act timer ran yesterday at 8:45 Eastern Time. The Speedy Trial Act contends that a case shall be dismissed. It does not afford judicial discretion. If trial does not commence by that date, no continuance was requested by the state. And as a matter of law, this case is dismissed and the court does not have judicial discretion to continue the case sua sponte prior to the expiration of the Speedy Trial Act. There's case law to support this if you're interested, but I'm sure His Honor is familiar with it.
I am not. Your motion is overruled. Once again, this was because of a matter of scheduling, which is an established principle to allow for a continuance. This was one that the court did sua sponte on the basis that counsel's availability was highly restricted. It is 1 day, Councillor Murdank. I don't think it prejudices your client that much.
Your Honor, which line did you grant the continuance on?
I did not grant the continuance. No objection was made, no motion was made for dismissal on the basis of the date. Nothing was raised from yourself, Councillor. Doing it at the date of trial with all witnesses gathering is frankly rather shoddy on your part. Any other pre-trial motion?
Oh my God. Oh.
Certainly, Your Honor. We have two witnesses that we introduced on the docket, Mr. Guba and Ms. Rossi. Your Honor had asked that we raise those before trial today.
Yes, indeed. Counsel, this is your opportunity to respond to what was on the docket, essentially. If you've got any other further points that you'd like to make, or if you'd like to stand by your arguments, that's reasonable as well. Court is ready
Your Honor,
in any event.
Certainly, I'm sure His Honor reviewed the case law that was presented today and understands the relevance of Mr. Guba and Ms. Rossi's presented testimony that is likely to occur as a result of Ms. Price's testimony. We'd ask His Honor to take that into consideration.
The court does take that into consideration, and the court will be granting these additional witnesses. The court finds it to be very reasonable in the circumstances to provide some modicum of testimony in order to bring any evidence to light which may grant the court a reason to question the authenticity of evidence delivered by, or rather testimony delivered by that officer. So that will be granted. And both individuals.
I look
However,
forward to this.
As stated on the docket, and in the in large part in the
well, to be like
in
that
the
we'll see what they have
in
to
the
say.
sidebar,
That's
we'd like to be
apparently
able to
so
try and keep
important.
very much to time. So I'd appreciate it if you could do that, Councillor. But I do understand if it is a tricky matter.
Your Honor, the defense would assert that the major time constraint here today is going to be the prosecution's presentation of its case,
agree.
given that we can't get to our case in chief until they finish theirs.
I
Certainly happy. Yeah,
I do
certainly
agree.
happy to.
The main matter that I raise here is just that I do not want to go into elements which may not have any relevance to the testimony at hand. We want to keep it entirely to scope if we can. That's essentially the order there, is just maintaining to the scope why they were asked, why they're called to trial, so that we don't get into an unnecessary lengthy examination of a witness.
Oh yeah, certainly, Your Honor. I understand there are certain matters that may be more appropriate for a civil case, and we'll keep those to that forum.
Outstanding, counsel. Is there any other pretrial motions?
Your Honor, I'd just like an objection noted for the record for appeal about your ruling on the for violation of the Speedy Trial Act, given that it does not afford judicial discretion.
That is noted.
I'd also like to. Thank you. I'd also like to ask His Honor whether today's hearing is being recorded, given that there is no sign placed and no clerk present.
It is not, as we do not have a clerk present for this. However, I will make direct reference to this in my ruling as a point of the judgment at the end, so that way you are able to appeal appropriately.
Your Honor, if we don't have a clerk present, how are we supposed to preserve the record for appeal?
Unfortunately, I could not advise on that. The only thing that I can do essentially is provide you with the ruling, which is essentially exactly what I've said, and then afterwards you can take it from there.
All right, then we move for a continuance so that we can have a transcript of these proceedings if they are going to proceed.
Okay. Counsel for the state, do you have any objections to a continuance?
I would object. All of our witnesses are here.
I find it. Your Honor, the state would object. All the witnesses are here. We have all gathered. Defense counsel themselves just brought up the fact that the case matter was already going to. We would ask that we just continue today. Like, I'm sorry, you can't just ask for like.
We'll go into brief recess. We'll have a look.
I would also assert that there have been many
I'm not
appeals.
entirely sure if we can, but
have
it
been
will
based
be
off the
attempted
judicial
at the
ruling.
very least. Furthermore, I will reiterate my point in respect of the Speedy Trial and Bail Act, so that way it is preserved for the purposes of appeal.
Thank you, Your Honor.
Court is in recess. Thank you very much, counsel.
Let me see if it says it. Which case was Logan Kingsman? 2024.
It should be in the appeal.
It is.
Yeah, it is 2024 CM 326.
I can guarantee he's going to try these same arguments tomorrow.
Yeah.
And I would also argue that the appeal that they themselves cited that was so successful, a transcript was also not provided.
Yeah. Maybe it's just because they were competent lawyers on that one. I don't know.
That would be my argument. Oh my God, I love it here so much.
So like, I don't really know. Should this is the judge doing a bad thing or what? Like with the whole speedy trial thing.
No, I think it's fair. They scheduled it as soon as possible. I guess it was just outside. They want to appeal it based on that and say that he can't be charged at this point because he violated the Speedy Trial Act. Well, that's counsel's fault. They weren't available.
I'm also pretty sure there is case law. There's appeal actually. I think that says like continued engagement with the docket basically is implied waiving of STA.
Where's that at?
I have it somewhere in my library. I gotta.
But I don't think
he's
that
already,
it should be
he's
continued.
already ruled on it, so that's just something that the Supreme Court has to look at.
Is there nobody here that can record it?
I guess no. No court clerks around.
I do find it interesting, though, that the case that they cited for support of dismissal is, in fact, an appeal that was done so without a transcript.
Or he also argued like, "Oh my God, we can't do it today because my client's rights have been violated, but I'm willing to wait another 2 weeks to do it, so a court clerk is around."
At least you can anticipate the same arguments from him tomorrow at the soap trial.
Yeah.
Yeah,
that's what we already
no,
said.
yeah, but
And that makes me wonder whether we should get judge signed warrants now for Miller and Stephen.
Oh, no, I'm definitely going to get judge sign warrants for Damian Flippington, Carmelo Kandinsky, and Mr. Burgess. I'll just submit those later today.
Because that was something else that he pointed out. We don't have to have a judge signed warrant unless we think we're not going to apprehend them within the statute of limitations, which we did. So, I mean, I respect him trying, but
Yeah, I get the arguments. Like, I'm not against the argument. It's what I don't like is my time being wasted. Why would these not matters on the docket? Like, I took time out of my day to be here today.
yeah, no, exactly.
None of the cases cited by opposing counsel include a transcript. Oh wait, no, there's one. Only one of the three.
Well,
if
it's
that
whatever
case,
fits his argument.
if there's been appeals without a transcript before, then we shouldn't need one here.
Yeah. Which is most likely what they will come back with.
But yeah, I feel like he's comment about the Speedy Trial Act he could have done on the docket before we all got here. He's concerned
that's
for there
a
not
Matt
being
Murdank
a court clerk.
classic. I'm gonna keep all this to myself and make a bunch of pretrial motions and catch them off guard.
I mean, I get it. Maybe with some judges it would have worked, but
No, I can almost guarantee you it's going to work tomorrow.
Yeah, that's my concern as well.
depending on how today goes, though, can't you amend the charges? Question mark.
Hey, guess what?
No,
guys?
but
I'm gonna
we
be
have
a
to do it
clerk
in
today.
Discover.
Oh my God,
I'm an
it's
associate
amazing.
Justice clerk. Let me put my sign up.
Oh, look at that. No reason not to proceed. Now there's a clerk.
Yeah, so.
Okay. I may have to dip. So.
Oh, it's okay. What's going on? You just gotta go to sleep.
Yeah, I got an early date tomorrow.
Now back in session.
Let me know.
I will be in one moment. I need to.
Yes.
Tag my sign. and-
No, don't apologize. It's fine. We'll wait
Okay,
for the Associate Justice to prepare her transcription matters. You all set?
One more moment. Just gotta get this computer booted up. Any new tech in here? Alrighty, we are good to go, Your Honor.
Outstanding. Okie dokie. Court is back in session. So, unfortunately, due to we now have a clerk present, so I trust all the pretrial motions that were made are fine to be off the record, aside from one, which is in respect of the Speedy Trial and Bail Act. Now, essentially, the arguments by the defense boiled down to being that the date the trial was scheduled, the purposes for the Speedy Trial and Bail Act date is the 9th of April, subject to time zone, I suppose. Unfortunately, it's a bit of a tricky one for me, as I'm sure you can understand. And then afterwards, the motion to dismiss was on the basis that this is a day after the STA date. The court will state that this is reasonable. This is something that the defense ought to have brought up, and through, unfortunately, the availability of such, the availability, unfortunately, was very, very restrictive. There was barely anything, as you saw. It was submitted to the docket showing such availability, so that was made so that could be that was publicly available. That's available upon line 21. The court will say that essentially we are proceeding to trial, and that the motion to dismiss was refused, was overruled. Apologies. Was there any other pre-trial motions that anyone would like to get on the record before we proceed into trial proper?
Yes, Your Honor. Some additional clarification. Could His Honor please explain for the record how he reconciles his ruling with Section 6.1 of the Speedy Trial Act?
The court will need to quickly review Section 6.1 just to be certain.
I can email you that as well, Your Honor.
Oh, thank you. Yes, please, counsel. Much appreciated.
Mr. Ward would also appreciate if the court could distinguish this case from the other matters where the cases have been dismissed with prejudice pursuant to the Act.
Of course.
I don't think they were dismissed.
I don't know them. Well, I don't know every single case at the top of my head.
Okay, so the court is looking now at Section 7, subsection 7, which states issues of scheduling should a witness, the attorney for either party, the presiding judge, any pertinent person involved in the trial, or the accused be unable to make the scheduled court date, pertinent pretrial hearing, or there are issues in finding an appropriate time for the majority of all parties, the trial court may authorize an extension to the protections under this act. Of course, by us scheduling this a day later, that is, of course, what I would say an implied continuance in this matter. And that is essentially the reasoning behind it. In terms of distinguishing, unfortunately, I do not have any case law to hand to support that. And to be honest, we are 38 minutes into the start of the proceedings, and I would prefer to get into trial if counsel is agreeable.
Last question, Your Honor. Would you state for the record that His Honor did not make any explicit continuance on the docket?
It's quite clear from the record on the docket, I did not. It is implied from the date outside of the Speedy Trial and Bail Act. The record should also reflect that defense counsel did not raise this at any time. All right, now we will proceed with the matter at hand. State your case, call your first witness, or present your first piece of evidence.
We're calling you first, right? Or do we want to submit all the affidavits first?
I would assume, Your Honor, by that we're waiving openings.
Oh, no. If you want to do openings, you're more than welcome to. Apologies. That was my bad.
Won't do an opening.
State if you'd like to present your opening.
Yes, Your Honor, one more. Your Honor, people of the Gal. The situation we are here for today is simple and clear. We will show today through testimony and material evidence that Mr. Wood was present at a violent altercation between himself, other suspects, and law enforcement officers. We will show today that Mr. Wood actively participated and assisted in this violent altercation by using his own weapon, stabbing multiple officers. We will show today that Mr. Wood and his accomplice led officers into a planned ambush and actively assisted in the premeditated attack on law enforcement. The definition for first-degree murder is clear. I sure hope we don't need to argue today that stabbing or shooting people is an action that could reasonably be expected to kill someone, so the burden comes down to planning and premeditation. We will show the courts today that the ambush was done deliberately, it was not an accident or coincidence, that the ambush was targeted at law enforcement and not just random people, and finally, that the ambush was planned with sufficient separation in time, place, and behavior of the suspects. Thank you, Your Honor.
Thank you, counsel. And
I
defense,
like that.
if you'd like to present
Like
your
how you
opening.
included the separation.
Yeah, because that's the Logan Kingsman thing. I was looking
Your
at
Honor,
that
what
before.
kind of crime that is deliberate, planned, and targeted involves friendly fire and bringing a knife to a gunfight? In the matter at hand, Mr. Ward was equipped with a knife, which the state admits. The officers and the individuals involved were engaged in friendly fire.
No.
The testimony today will not prove beyond a reasonable doubt that Mr. Ward engaged in a deliberate, planned, and targeted attack on officers because no such plan happened. What actually happened was that officers left Mr. Ward in a pickle. He and his alleged co-conspirators were present on a scene, attempting to flee from police, and as a result of the actions of the police, felt that they perhaps had no other options. The case law is clear. Not only is it the case that an individual does not necessarily need to be quote unquote out of options in order for an offense to be second-degree murder, they can have other options available to them, nevertheless decide to engage in violence against officers, and it still isn't necessarily first-degree murder. The officer in court today, both as an attorney and a witness, has repeatedly pursued unfounded first-degree murder charges against defendants over and over in the state of San Andreas.
You've done it
It
once
is not
before, right?
enough that she has lost each time she tries to do it. She is continuing
'Cause I
to
don't
do
know
it
any other case
despite
law
not
that
having the evidence,
pushed.
despite not having the law, merely as a means of inflicting terror upon the defendants that face her wrath.
Oh my God, I'm
In
terrorist.
this particular case,
That's crazy.
Mr. Ward's rights have
Terror
already
Khalifa.
been violated. They've been violated by the state's efforts to charge in the alternative. They've been violated by the state's continued pursuit of this case, despite the Speedy Trial Act having run. And they've been violated by the knowing and intentional charging of offenses that are beyond the pale based on the facts at issue. You cannot possibly tell me that a case that involves friendly fire was intentional,
no friendly
planned, and
fire.
targeted. They were in the tunnels of the subway. They were running up the stairs, attempting to flee from police. Police started preventing them from fleeing the tunnels, and someone decided to shoot. There was not a death trap or a block or anything of the sort that has been discussed in these prior cases that have found attempted first. This
gotta ask
was
if you
a
prevented
crime
them
of
from leaving.
circumstance. And in fact, Mr. Ward admits that. Officer Price was in the cells with myself and Mr. Ward and offered the opportunity for Mr. Ward to plead no contest to aggravated attempted second-degree murder times 6. She said, no, it's first degree. And we said, okay, not guilty. We'll go to trial. Well, here we are. And on the eve of trial, the state has attempted to change Mr. Ward's charges to second-degree murder, except not even.
We didn't
They want to
attempt
have it
change
both ways. Now, they didn't raise
You
this
didn't.
before trial, so it's not before the court, but it does evidence their intentions. They understand that this was not first-degree murder, and they nevertheless want to persecute Mr. Ward for exercising his rights
not. Okay.
under our nation of laws. This cannot stand. The court should find Mr. Ward not guilty, both on the basis that the conduct alleged was not deliberate, planned, and targeted, and on the basis that the state has continued to pursue a pattern of abuse in overcharging individuals like Mr. Ward. The court will also hear from Mr. Guba and Ms.
Also
Rossi
note that
about
Mr.
their
Kingsman was
experiences
found
with Ms.
guilty.
Price specifically. This is an unacceptable pattern of conduct, and the court should not allow it to continue. Thank you.
Thank you very much, counsel. Now, with openings out of the way, we will move on to the state's case.
I say we
State,
submit the
please present
affidavits.
your first witness, or
Now,
present
all of them?
your first piece of evidence.
All of them, right?
The
Are they all
state
on the same-
would move to
go ahead.
enter into evidence state exhibits 22A and 22B on line 24 and 22C and 22D on line 31. These are the affidavits from officers Blackmore, Sterling Locke, Liam McGrath, and April Storm.
Does that not include E? Just for clarification.
Officer Diaz is present in court.
Of course. All
You
right.
are present,
Any
correct?
objections from defense counsel?
I am, yeah.
She is present. Yeah.
Yeah, Your Honor. I have some notes on this. Could you just give me a second? I wasn't expecting these to be right away.
Not a problem.
Your Honor, just as a brief overview to give yourself some time to maybe start looking at these, we're going to be objecting to certain of the affidavits, or at least asking His Honor to take into consideration that there are conflicting remarks in both the indictment and the affidavits, and that the strength of the affidavits, even if they're perhaps not perjury, although they are sworn under penalty of perjury, should be, considered as lesser evidence on the basis that they do conflict with each other. So just give me a moment.
Understood. Yes, of course. If you had the headings to hand, that would be appreciated.
Yeah, I'm working on getting you the details, Your Honor. So Sterling's statement, Your Honor, Mr. Locke, I don't know which exhibit this is, but he indicates that he followed the pursuit in his vehicle up until the suspects did a vehicle swap in Legion Square, where the suspects pulled the vehicle into one of the side pedestrian entrances of the square and proceeded to dismount and run around. Two suspects ran back to the vehicle and ran one of them into a pink-fisted growler. That does not line up with the initial docket filing. And then 1 second, Your Honor.
Would it be all right if we did these in sequence, if that's all right, Counsel? Just so that way we can get any responses to the objections, etc. So, for example,
I think I have one more for this affidavit. If you'll just give me.
Not a problem. Not a problem.
That's it for Mr. Locke, Your Honor.
Okay. State, do you have any rebuttal to that, please?
In regards to inconsistencies in the indictment and the statements, the state would assert that people see and experience things from their own perspective. They have varying memories, and everybody does their best to recall to the best of their recollection. Obviously, it would be ideal if everything was all the same, but we're not all the same people.
He did also say on the docket that they got into a fist of growlers.
Your Honor, the defense couldn't agree more, which is why the court should give less evidentiary value to the statements and the indictment as a result of the inconsistencies.
I would agree.
Your
I'm
Honor,
just asking the court to take that into consideration in your weighing of the evidence.
No, absolutely. Yes, the court will take notice of that, and whilst the objection is overruled, judicial notice is taken, and Corporal Sterling's Locke, his affidavit will be viewed with a heightened degree of scrutiny moving forward. I'll just put a note on this 1 moment.
If I may, Your Honor, the state would assert that the core information within the indictment and across the affidavits is consistent. Suspect entered a pink growler. The indictment asserts and identifies the vehicle as a pink growler. I wanted to summarize them. He's not going to give me the opportunity.
This is noted in the statements of facts. Yes, you know what? We'll go for one more volley, actually. I'll reconsider that. Defense counsel.
Your Honor, apologies. I didn't realize you were still talking about this. Could I ask the state to repeat their argument?
The state would simply asserted that the core components between the initial affidavit or indictment and this affidavit specifically are consistent with each other. The vehicle in question, a pink growler, is consistent, listed in the indictment and identified as well in this affidavit.
Your Honor, we're not saying that there isn't a pink growler in both statements. To be clear, it's more about the details, which are obviously very important as a matter of making fact-finding determinations in this case. The ask here is that the court considers and reviews the differences between the indictment and the affidavit, including the example given, and as a result determines whether or not any officer's memory is reliable.
Oh, well, I guess
it's not an objection to the filing. It's just asking the court to weigh the evidence, given that we can't cross-examine the witness.
Yes. No, indeed. No, that's most reasonable. Yes. The court will take notice in respect of, just to be clear, Sterling Locke's affidavit only. At this stage, in any event, I trust you have more, so we will go into.
I sure do. Are we ready for the next one?
We are. Yes. Thank you, counsel.
All right, Layla Diaz. Her statement indicates that the pursuit went on foot for some time, leading to Legion Square, where 3 times individuals exited
Your Honor,
the
we didn't
vehicle.
submit Layla Diaz.
Oh, okay. Apologies. I'm just going down my list of affidavit objections.
Thank you.
That's fine. We'll move on to the next one in that case. All were submitted aside from Layla Diaz for your.
All right, I think we're good for now, Your Honor. We're trying to be expeditious.
Thank you very much. Yes. No, we in that case, those affidavits are approved into evidence and are noted. However, the affidavit of Sterling Locke will be viewed with some degree of higher scrutiny, if you like, due to the alleged inconsistency. Anything further, State?
I don't think so. I'm going to provide a brief summary of Sterling Locke's affidavit after Logan Graver's testimony.
Good. Sounds good. I'm going to call you then. Callie?
Yes.
I would like to call Callie Price at the stand.
Outstanding. Lieutenant Price Cutter, if you'd like to take the seat in the witness box, and my bailiff will swear you in.
Would you like an oath or an affirmation?
I'll take a oath today. Excuse me, an oath is fine.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
She's been sworn in.
Thank you very much, bailiff. Counsel for the state, your witness.
Thank you, Your Honor. Hello. Could you give your name, rank, and experience for the record, please?
Officer Lieutenant Kelly Price Cutter, San Andreas State Police. I've been employed for just over 3 years.
All right, thank you very much. Were you on duty on March 17th, 2026?
Yes.
Do you recall being involved in a pursuit on that day?
Yes, I was patrolling with Cadet Brennan Stewart. We engaged in a pursuit following a Fleeca Bank robbery on Great Ocean Highway and caught up to the pursuit at Legion Square.
What did you observe when you joined the pursuit?
I was notified that the vehicle had stopped on the east side of Legion Square, and officers informed us that the suspects had exited the vehicle, were fleeing on foot. Myself and Cadet Stewart routed around to the other side of Legion Square, where we noted a suspect entering into a Vigero registered to Marcus Ward, as well as a different suspect had entered into a pink growler, and then 2 suspects had returned to the initially pursued vehicle. A split pursuit was initiated between officers, and myself and Brendan Stewart pursued the Vigero before we lost visual.
Was anyone able to affirm the license plates of these vehicles?
Yes, we were able to obtain plate locks for all of them.
All right. Who were these vehicles registered to?
The initial vehicle of the pursuit was registered to Avery King, license plate Hearts. The pink growler was registered to Avery King, and the Vigero was registered to Marcus Ward.
They would like to enter Exhibit 7B to 7C on line 7.
7B and C, was that?
Yes, Your Honor.
Together with all the subheadings, yes, of course. Defense counsel?
Sorry, repeat that one more time, please.
Counsel.
We'd like to submit Exhibit 7B and 7C.
Well, where's my evidence?
Sorry, I missed that, counsel. If you said something, I just
no
caught
objections,
the end.
Your Honor.
Thank you very much, counsel. Those are admitted. Counsel, proceed.
Did any other units ever attach to this pursuit?
Yes. Officer Sterling Locke, who was previously attached as a ground unit, had pulled the helicopter with Logan Graver as co-pilot, and they pursued the growler, which we attached to later.
Did you ever catch up to the pursuit?
Yes, we caught up to it. Officers indicated the vehicle entered the tunnels behind Mission Row, Myself and Cadet Stewart entered shortly after.
Did you observe the pink growler in the tunnel?
Yes, we were a little bit far behind. Officers that were pursuing directly behind indicated the vehicle had turned around, so Cadet Stewart and I had stopped at one of the tunnel splits and set up spike strips.
Did the growler pass over the spike strip?
Yes.
What happened after it passed over those type of spike strips?
Unfortunately, I also spike stripped pursuing Officer Dexter Cutter and Layla Diaz's vehicle, but the suspect vehicle became disabled.
Did you observe any suspects at this time?
Yes, a male that was wearing a black and beige or white top with and black pants with white accents missing his left hand exited the vehicle and began fleeing on foot.
Were these suspects apprehended at this time?
He was not.
Why not?
He was observed using his radio. Shortly thereafter, a blue Sasquatch registered to Marcus Ward arrived on the scene. The individual made multiple attempts to enter the vehicle as a passenger. We deployed multiple tasers, but he was ultimately able to enter the vehicle and he fled the scene.
Can you describe the driver?
The driver of the Sasquatch?
Yes.
He was a male. He was not wearing a shirt. He had on a motorcycle helmet, black, and he had a full sleeve tattoo of red and black on his right arm.
Which direction did the vehicle?
I'm sorry, I didn't hear you.
Which direction did the vehicle flee?
The vehicle fled further into the tunnels.
Did anyone pursue this vehicle?
Yes. Myself and Cadet Stewart quickly re-entered our patrol vehicle and headed further into the tunnels behind the fleeing suspects, and officers Diaz and Cutter also attached a little bit behind us.
Did you ever catch up to this vehicle?
Yes. Myself and Stewart caught up to it first with Diaz and Cutter behind us. We caught up to it pretty quickly as officers had deployed spike strips on the Sasquatch before it had fled the scene. We passed a couple of different pedestrian platform exits, and the vehicle stopped at a third exit platform that was below Maze Bank. The suspect exited the vehicle and started running up the stairs with all available ground units pursuing them on foot. We were right behind the vehicle, and officers Cutter and Diaz were on the other side of the platform. They had entered in to the other side of the tunnels and had also stopped to pursue the suspects on foot.
Did the suspects walk/drive past any other exits they could have taken?
Yes, we passed two separate pedestrian platform exits that they could have fled to.
Were any suspects apprehended at this time?
No.
What did you observe the suspects doing at this time?
The suspects ran up the stairs from the lower platform towards the upper platform. When they got to the top, they started running around in circles, started tackling officers. They were also observed using their radios, but I couldn't hear what they were saying.
What direction were the suspects moving?
Again, they were just running around in circles, running back on themselves on the upper platform, tackling officers. You don't have to ask that question.
Throughout this incident, did you ever observe the suspects? Nope, sorry, one. No, we already cleared that one. Based on your training and experience, what does the repeated use of radios by multiple suspects indicate?
It indicates that they're communicating with each other or somebody and coordinating.
In your professional opinion, as a law enforcement officer, why would suspects just run around in circles and tackle officers when they had a clear path of escape?
In my experience and opinion,
Your
I
Honor,
believe...
objection, speculation. There's not enough foundation here to establish she's an expert about why people run in circles.
Agreed. Sustained. You'd like to
At
move
this
on, Council?
time, yeah, yes, Your Honor. Yes, Your Honor. I'm just sorting my question. Did you have any units like ready to apprehend them once they got out of the subways?
Once they, if are you asking when they exited the subway?
Yeah, if they had exited the subway station.
We had a helicopter above ground. That was the only mobile unit we had at that point.
Did you have any ground units ready to chase them?
No, all of the involved officers had abandoned their vehicles in the tunnel and had pursued the suspects on foot up the platform.
Speaking of radios, earlier, did you receive any radio communications made to officers at the time the suspects were fleeing on foot in the tunnel?
Yes. Logan Graver, the co-pilot of the helicopter, expressed that a blue four-door vehicle was observed circling tunnel entrances and had stopped at the Maze Bank. This was relayed about the time that we had arrived at the Maze Bank below where the suspects exited the blue Sasquatch and started running up the stairs. He later advised that we might have guns coming in as we reached the upper platform.
What was your response to this information?
Dexter Cutter advised over radio that he was going to go ahead and moved in that direction towards the potential incoming individuals. I moved past the suspects that we had been chasing on foot to back him up. He was a little bit further ahead of me, and as he rounded the corner towards the exit stairs, he was immediately shot down with shotguns. I moved to take cover behind a pillar because I was also taking fire from two suspects armed with shotguns, and I returned fire from behind the pillar. I shot one multiple times before I was shot down from behind.
How much time passed between the entering of the tunnels and the ambush?
A couple of minutes, maybe. It really wasn't that long. They proceeded up the stairs almost immediately after exiting the vehicle. They ran around for a little bit. And then shots were fired from the tunnel exit.
You said you entered the tunnels early. I'm asking from the moment you first entered the tunnels to the ambush. How much time passed?
That would be a couple of minutes. We spent several minutes attempting to apprehend the suspect that was trying to enter the Sasquatch. Prior to that, they had pursued the suspect in the pink growler, which turned back on itself and was subsequently disabled. We spent some time catching up to the Sasquatch, ultimately to where it stopped at that Maze Bank platform.
Did you prevent the suspects from escaping in any way?
No, they got away. But I don't understand that question.
In your professional opinion as law enforcement officer, was it necessary to start a violent altercation with law enforcement to escape?
Objection, Your Honor. What's before the court today is not necessity. That's scope.
Scope, yeah. Rebuttal, counsel?
The matter at hand here is if this is a escape, if this altercation was necessary or not, and we would argue that, you know, if there was no violent altercation necessary to escape, then that works for the defense.
Your Honor, as discussed in 2025 ACO 15, 2026 CM 004, and 2024 CM 261, the courts have repeatedly found, including on appeal, that it is not, as a matter of law, required to prove necessity in order to establish reasonable doubt about whether or not an offense was deliberate, planned, and targeted.
The objection was on scope, wasn't it?
Yes, Your Honor, because necessity is not for a determination as a matter of law today.
Overruled.
Can
Do
you
you need me to
repeat
repeat the question?
Yes.
Yes. In your professional opinion, as law enforcement, was it necessary to start a violent altercation with law enforcement to escape?
In my experience and opinion, no. They had a car waiting for them at the top with no available ground units to pursue them. They had a clear route. They were actually ahead of us when they got up the stairs. And had they kept running towards the exit, we likely would not have caught them.
What did the two suspects that ran around in circle do as soon as the shotgun started shooting?
Initially, they one was bandaging. I didn't have visual on the individual, Mr. Marcus Ward. They were behind me. Nobody had engaged them other than chasing them. And when we engaged in the shootout with the suspects that had entered with shotguns, and I was returning fire, I was shot in the back by one of the suspects.
Did the suspects make any attempt to flee the scene now that an opportunity was given to them?
To my knowledge, no. One of them started stabbing other officers on scene, and the other one shot me in the back.
Were they present for the shootout and actively participated and assisted in it?
Yes.
What did Mr. Ward do?
Mr. Ward pulled out a knife and stabbed two officers.
How many suspects total were in the tunnels?
At the culmination of events, 4 suspects were in the tunnels.
How many officers total were in the tunnel?
4 officers were in the tunnels, and 2 were in the helicopter above the tunnels.
Were you injured on the scene?
Yes.
Were you conscious at this time?
I was conscious.
Were you able to observe anything at this time?
Yes. I saw the suspect in the black and white top that had one hand. He was firing his pistol further inside of the tunnel. And the male suspect, there was a male suspect armed with a shotgun that had followed him. They later ran past me up towards the street or exit stairway.
Were other officers injured in this incident?
Yes.
How many?
5 other officers, aside from myself, were injured and or shot down.
Did these officers all press their panic button?
Yes.
Was the scene ever documented following this incident?
Yes, officers Liam McGrath, Caleb Blackmore, and April Storm took photos of the scene. Myself and Cadet Stewart also returned to the scene where the suspect had been tasered at the Sasquatch vehicle swap and took photos of that scene and collected evidence.
The state would like to submit Exhibit 11A to E and 11-9 to C. 9A to C, so.
What was that again, Councillor? Just so I have those.
11A to 11E.
Can we get the line?
Line 17.
So that's all of those subheadings under 11, yes?
Mm-hmm.
Okay. All right, defense?
Your Honor, we would just ask if this is only 11 at this time?
No, it's
would
also 9A
appear
and
so.
C.
Oh, 9A and C. Apologies.
Your Honor, no objections.
Okay, those are admitted, counsel.
Was evidence ever collected following this incident?
Yes. Officers McGrath, Caleb Blackmore, and April Storm collected evidence. And myself and Cadet Stewart collected the taser casings and DNA left at the scene of the vehicle swap.
Was this evidence ever submitted for analysis?
Yes, Detective Liam McGrath submitted the primary crime scene evidence, and Brendan Stewart submitted evidence from the vehicle swap for forensic analysis.
The state would like to submit Exhibit 12 at this time, Your Honor, on line 17 as well.
Is that A through E?
Yes, Your Honor.
Flawless.
No
Counsel?
objections.
No objections. Those are admitted.
What information did these reports tell you?
The reports from the primary crime scene of the shootout returned with 10 unique DNA profiles, 2 unique shotgun shell microstamps, and 6 unique 9mm pistol microstamps. Of the
Were you
DNA...
ever able to...
Oh, go ahead. Sorry.
Were you ever able to identify these unique DNA profiles?
Yes.
Who did these unique DNA profiles come back to?
DNA profiles returned to officers Kelly Price Cutter, myself, Dexter Cutter, Sterling Locke, Logan Graver, Layla Diaz, and Brendan Stewart. All officers, while employed by the department, have their DNA on file. DNA also returned to suspects Marcus Ward, Cameron Avery Soap, Damian Flippington, and Carmelo Kandinsky. Marcus Ward and Cameron Avery Soap's DNA has been on file for quite some time and has been maintained within department records. And DNA warrants for Damian Flippington and Carmelo Kandinsky had been served with their unique identifiers. DNA identifiers also being added to department records.
Your Honor, line 17 again. We would like to submit 13A to F and 14A to D.
Any objection from defense counsel?
Your Honor, 13 is fine. 14, I see a 14A. Is there another line that has B,
This is
C,
one
and
that I believe
D?
is staggered, yes.
It's on line 24.
Yes, apologies. I have
Your
it
Honor,
here
one
noted. Line
moment.
24.
No problem.
Yeah, that's fine, Your Honor.
No objections to 13 and 14, so admitted.
Are you aware of any connections between these individuals?
Yes. 3 of these individuals are self-identified as members of the Cypress Bravo gang. I've also encountered them multiple times and observed them wearing gang-specific or gang-affiliated masks and or pocket flags.
How do you know this connection? Beyond just your observation in the wild.
There was a civil docket recently, 2026 CV004, where 3 of the individuals whose DNA was recovered from the scene identified and asserted their membership upon that docket.
Your Honor, line 24, we would like to submit Exhibit 20A.
Any objections from the defense?
Yes, Your Honor. This is not relevant to the charges at issue. I understand His Honor made a previous ruling about this, but the line of questioning has not established foundation for why this matters.
Indeed, counsel, I would agree. At this time, that is sustained until foundation can be demonstrated why criminal affiliation is a matter at play in these charges. That exhibit will not be admitted.
Do your job, Ms. Frost. I believe in you.
In your professional experience as law enforcement officers, do people of the same gang usually help each other?
Yes. I would say, to elaborate on that, in this instant, we were pursuing a primary suspect from a Fleeca bank robbery where an affiliated individual and a vehicle registered to an affiliated individual was used as a pickup vehicle. Multiple vehicles returning to this person was used as a pickup vehicle, and DNA recovered from that scene returning to multiple individuals of the same organization would support that belief.
You mentioned a blue Sasquatch vehicle registered to Marcus Ward. What happened with this vehicle?
This vehicle was documented. It was towed back to RPD where it was fully processed. Fingerprints were taken from within the vehicle. Photographs were taken, VIN number, things of that nature. It was also, I believe, held for 48 hours pending investigation and forensic results.
Alrighty. The state would like to, line 17, submit Exhibit 7D129.
7D 1 to 9. Any objections, defense counsel?
Just a moment, Your Honor, for us to pull that back up. We're zipping back and forth here.
Not a problem.
No objections, Your Honor, to Exhibit 7.
So admitted.
Could you have a look at the Exhibit 7D, please?
7D?
Yes, 1 to 9, please.
Okay. I see it.
Is this the vehicle observed to pick up the fleeing suspect?
Yes.
Was any evidence recovered from this vehicle?
Yes, fingerprints were recovered from each individual seat of the vehicle.
Your Honor, the state would like to submit on line 17 a 8A to 8D.
Any objections from defense counsel?
Your Honor, no objections to Exhibit 8.
Thank you very much, counsel.
What were the results that you got out of the forensics report?
Fingerprints recovered from the driver's seat of the vehicle returned to the registered owner, Marcus Ward. Fingerprints in the front passenger seat returned to Cameron Avery Soap. Fingerprints in the rear right passenger seat returned to Damian Flippington. And there were some unidentified fingerprints in the rear passenger seat behind the driver.
You previously described the driver of the blue Sasquatch vehicle as having a sleeve tattoo of red and black. Did you ever see that tattoo again?
Yes. Once I obtained forensic evidence from the scene and got a match to Mr. Marcus Ward, I reviewed MDT mugshot photos of Mr. Marcus Ward, where he is documented with a tattoo that is consistent with the one observed as the driver of the vehicle.
Line 24, Your Honor. State would like to submit Exhibit 21A.
No objections.
Thank you very much, counsel.
All the questions from the state so far, Your Honor.
Excellent. Thank you very much, State. Defense counsel, your opportunity to cross.
Thanks, Your Honor. Permission to approach the witness and request for standing permission for the duration of the proceeding.
Absolutely. Thank you very much for that, counsel.
Perfect. I look forward to this.
Hello, Lieutenant. How are you?
Oh, I'm above average, Mr. Murdank.
I'm so curious about a few things. You've testified a lot today about what happened, and you've especially testified about what you saw, what other people saw. Let's first talk about the tunnels and the spike strips. Is that all right? Can we start there?
Sure.
Which vehicles specifically were spiked?
The pink Growler and Officer Dexter Cutter's patrol vehicle.
What about the Sasquatch?
I didn't personally deploy spike strips on that one, but I believe Officer Diaz deployed spike strips underneath of it.
So the Growler and the Sasquatch were both spiked then?
Not at the same time, but yes, they were both spiked.
The result was that they both ended up without the ability to operate?
No, the Sasquatch was able to operate. It drove away.
Really?
Yes.
Okay. Another question about upstairs a little bit. So I understand you guys were in the subway tunnels. There's a staircase. I've looked at all these photos. You said, and just this is me making sure I understand what happened. You said that everyone went up the stairs and then that was where the shooting happened. Is that right?
We went up the stairs. There's an upper platform and a corner that you have to go around. Go down a small hallway, and then there's a right turn you need to make to go up the stairs. The shooting happened at the primary shooting happened at the main stairs that exit the subway station.
And when did Mr. Ward shoot?
Mr. Ward did not shoot.
Really? Why not?
Because he stabbed officers with a knife.
Well, I assume that those two things are mutually exclusive, but why didn't he shoot?
I couldn't tell you. Maybe he didn't have a gun.
Maybe he didn't have a gun. In your experience, do individuals who possess both knives and guns choose to use knives instead of guns when there's a shootout?
I couldn't tell you. I've never engaged in a shootout myself using a knife or a gun when I had one or the other.
Let me put it to you this way. If you had the choice between a knife and a gun and you were in a shootout, would you pick the knife or the gun?
I would personally choose a gun.
That sounds right to me. You said they were stalling. Tell me more about that.
They had a little bit of a head start on us, and they went up the stairs. They could have continued running, but they started running back on themselves and running in circles. They started tackling us.
Was one of the individuals hurt?
I believe Mr. Cameron Avery Soap was eventually observed applying bandages.
And so is it possible that they were not stalling, but in fact trying to ensure that one of the individuals fleeing would be able to get out?
Based on the totality of the circumstances, I would say that they were stalling.
I didn't ask what you would say. I asked if it was possible. Please answer the question.
Oh, I believe anything is possible, Mr. Murdank.
Thank you very much, Lieutenant Price Cutter.
Oh, you're very welcome.
Now, you testified earlier both about Mr. Locke's statement and Mr. Graver's testimony. Would you help me with a discrepancy here? Because Mr. Locke's statement says that they drove from the downtown to the tunnel entrance directly, but earlier you testified that Mr. Graver said they were circling. How do you reconcile that?
How do I reconcile it is that they were going to multiple tunnel exits, trying to identify and locate any potentially involved pickup vehicles.
So, Ms. Price Cutter, in your experience, looking for multiple tunnels is consistent with going somewhere directly? You think those two things are the same thing?
I don't believe the officers went anywhere directly. They observed a vehicle moving directly towards the specific Maze Bank tunnel entrance. where the vehicle was observed to stop.
Correct, but your testimony also is that Mr. Graver said they were circling. I just don't understand. How do you? Those seem to be inconsistent to me. Help me figure that one out.
Well, I couldn't tell you, sir. I wasn't in the helicopter.
But would you agree that those statements are inconsistent?
This is exactly what he does. I believe that it's a matter of the perspective of the individuals that observed it.
All right, so I'll just read you the statement. Maybe that will help. While flying from Boulevard del Perro to the Morningwood area, myself and Graver spotted a baby blue Albany V-Star traveling from the direction of BDP, proceeding directly and without deviating nor stopping straight to the Morningwood/Vespucci Maze Bank Metro Station entrance. Whereas you said Air One witnessed a blue vehicle circling tunnel exits. Which one of those is the truth?
Well, one of those is from Mr. Sterling Locke, and the other one is a radio transmission that I heard from Logan Graver.
So you weren't present for either of those? You didn't participate or see either of that?
No, I was inside the tunnels chasing the defendant Marcus Ward and Cameron Avery Soap.
That's right. And so you can't say with certainty what actually happened above the tunnels?
Hell, that's why there's affidavits and other officers to testify.
All right. And you said earlier that you didn't prevent the individuals from leaving. Is that still your testimony today?
Well, they got away.
I don't believe that's what you were asked, Ms. Cutter-Price. You were asked, did officers prevent the individuals from leaving? And your answer was no. Do you want to change that testimony?
I don't believe so.
Well, you also testified that they were tackled. Were they tackled?
They tackled us, and we tackled them in return.
Okay. And were tasers deployed?
Tasers were deployed when the defendant, or not defendant, when the other suspect, the one-armed individual, was attempting to enter into the blue Sasquatch truck.
I see. So he was attempting to enter a truck and you tased him. Why do you think he might have been... Sorry. Was he attempting to get away?
Was he attempting to get away? I would presume so.
All right. And you said earlier that the vehicles were spiked? That's still your
yes.
testimony? And were the vehicles also boxed in by officers at any point?
Not to my knowledge, no.
Were there efforts to box in the vehicles?
I don't believe so.
Okay. But nevertheless, it's your testimony that individuals were tased and tackled while making efforts to flee. Is that right?
They were tased and tackled. Yes, they were tasered when they were trying to enter into the vehicle, and we tackled them when they tackled us.
But it's also your testimony that you didn't prevent them from leaving?
I mean, we attempted to prevent them from leaving, but we were unsuccessful. So no, we did not prevent them from leaving.
I see. So you did try to stop them from leaving through tasing them, tackling them, and spiking their vehicles. That's your complete testimony on the record today.
Can you repeat that?
It is your testimony that you attempted to prevent them from leaving through tasing them, tackling them, and spiking their vehicles. Is that correct?
Well, I'm sorry, one more time.
It is your testimony today that you attempted to prevent them from leaving by tasing them, tackling them, and spiking their vehicles. Is that correct?
Yes, we tasered them. We tasered the one suspect.
Can I get a yes or no, please?
Then it would be no, we didn't ever taser the defendant, Mr. Ward.
The individuals on the scene. Did you attempt to taser any of them?
Yes.
I said them, not Mr. Ward. Okay. So, just to make a complete record, Ms. Price Cutter, is it your complete testimony today that you did attempt to prevent the individuals on scene from leaving as a group, both officers attempting and individuals attempting to leave through the practices of tasing, tackling, and spiking.
Sure, we tackled the suspects when they tackled us. We tasered Mr. Soap, and we spike stripped the Feister Growler and the Sasquatch.
And have you ever been in a situation like this before?
Yes, many times.
And you ever pursued attempted first-degree murder charges against someone for the same kind of situation?
It was a different situation.
Same kind of situation?
The same kind of situation. Similar situations.
Well, it was your testimony earlier today that it was not necessary for them to shoot. Is that right?
That is correct.
Have you ever given similar testimony in other cases?
I couldn't recall. There a long time ago.
Have you ever made similar arguments in other cases?
I couldn't recall.
Allow me to refresh your memory. Would you please open on your tablet there 2026 CM004?
Objection, Your Honor.
What is the objection?
That state has not been submitted into evidence.
Your Honor, pursuant to the procedures of the court, cases do not need to be submitted into evidence if they are internal case law.
Agreed. Yes, overruled.
Okay.
You familiar with this case?
Vaguely familiar, yes.
Were you an attorney on this case?
No.
Did you testify in this case?
I did.
Did you pursue charges in this case? Are you responsible for the charges that were pursued?
I posted the docket, so I would assume so, yes.
Did the charges in that case resemble the charges in this case?
These individuals robbed an ATM. But yes, the main charge in hand was the attempted murder in the first degree.
Why did you pursue those charges in that case?
That would be because we were chasing suspects. They had two of their individuals who had fled on foot, hiding in stage underneath of an overpass. And as we pursued one of the suspects, they led us directly back to the overpass, where the suspects that were waiting ran out and started stabbing and chasing down officers.
Does that sound familiar to this case?
No.
Why not?
I would say that this one case differs from that one. Number one, this was a bench trial. But secondly, differing from this case is two armed individuals entered into the Maze Bank subway station entrance armed with Class 2 shotguns and immediately opened fire on law enforcement officers upon contact.
How is that different?
How is that different from this one? Because nobody else just arrived on the scene and coordinated their arrival. They were already on the scene in this case that you have presented.
In the underlying case, did you testify that it was a deliberate, planned, and targeted attack against officers?
Are you talking about this one being the underlying one, CM004?
Exactly.
Can you repeat the question?
Did you testify that it was deliberate, planned, and targeted in that matter?
Yes. Because it was.
Why?
Because I believed it was, as the suspects, who nobody had been chasing, were staged under an overpass and waiting with knives. And a suspect that we were chasing on foot lured us directly to their location, where they emerged and began swinging those knives and other weapons, stabbing officers on the scene.
What about that was deliberate to you?
The fact that they were waiting underneath the overpass while we were being lured back to their location, where they ambushed us with those weapons.
And is there anything about that matter that you haven't described here today about the difference?
Yes.
You want to be more specific?
Well, like I said before, Mr. Murdank, in this incident, 2 suspects drove across the city to the exact location where
Sorry,
these
sorry. I
suspects
meant
were
about
heading.
the facts of the other case. What is there anything specific about that case that you haven't testified about? Anything in the judge's ruling, perhaps?
I mean, if you want to know the judge's ruling, why don't you just read it for the court?
Sure, great idea, Officer Price Cutter. It was the state's argument that a deliberate, planned, and targeted attack against officers. That the suspects may not have planned to crash and have their vehicle disabled where they did, but that they did eventually plan to attempt to take the lives of these officers at an alternate location. It was stated in the state's closing that it's unclear if their intention was to stop at that location. It's not clear, but that they wanted to attack was clear. That's an interesting analogy to this case. Do you think that these two cases are similar?
There are similar elements, but they are not the same case, Mr. Murdank.
And you're alleging in this case that there was an intention to attack?
Which case? You got to be more specific.
The case before the court. Sorry, the case before the court. You're now alleging.
Yes.
How do you know?
How do I know? By the actions taken by the defendants, the suspects in question. The coordinated arrival
specifically, what specifically indicates to you that they intended to attack prior to their arrival?
The coordinated arrival of the vehicle coming to the exact same location above ground while the suspects ran up the stairs and then stalled while suspects immediately exited the arriving vehicle, armed with Class 2 shotguns, entered the subway tunnel, and then immediately opened fire on law enforcement officers.
You don't think it's possible that the individuals attempting to flee from you were intending to get into that vehicle and leave?
No, I don't.
Why not?
I mean, that was their ultimate goal, was to get in that vehicle,
Officer,
but...
why not?
Oh, I didn't hear you ask a question.
Apologies, but go ahead. Why not?
Why did I believe that they were not?
No, why don't you believe that it's possible that they were going to get into that vehicle and drive away?
Because the operator of the vehicle had exited and entered the tunnel with a shotgun and started shooting. I mean, of course, ultimately they did leave in that vehicle. But their plan was to engage and shoot down law enforcement officers prior to leaving in that vehicle.
And how do you know that the individuals in the car planned on shooting in advance?
Well, because they got out and immediately armed themselves with shotguns and entered into the tunnels and immediately used those shotguns to shoot at officers.
So it's not possible, in your view, that they chose to shoot upon arriving once they understood the circumstances?
I'm sorry, can you say your question one more time?
You don't think it's possible that they chose to shoot after they arrived?
No, I believe they exited that vehicle and came into the tunnels with the intent to shoot.
Do you have any evidence that they planned on shooting before they arrived?
I would say, again, the repeated visual of them consistently using their radios combined with the coordinated arrival of that vehicle to the scene at the same location that the suspects were headed to, that we were pursuing on foot, would clearly outline that.
In your professional experience, have you ever seen a car arrive at a location where people don't get out and start shooting?
Yeah.
Many times?
Several times. It happened at Legion Square. They had vehicles staged there. Suspects got out and got into those vehicles. Nobody shot there.
And you said that it was the individuals who came down the stairs that shot first?
Yes.
That's so interesting to me. So the individuals who you were closer to and had an earlier opportunity to attack you didn't attack first. Is that right?
That is correct.
And in fact, were they on the opposite sides of the people who came down the tunnels?
Myself and Officer Cutter were between the initial fleeing suspects and the suspects that came down the stairs at the time the shooting occurred.
So they were shooting towards the other people?
They were shooting towards us.
So you just said that you were between the two groups of individuals. Is that right? There's two people ahead of you and two people behind you?
I would say, judging by the officers that were shot down by the individuals shooting the shotguns, they were shooting at us, myself and Dexter Cutter to be specific.
That's what I asked you, Miss Price Cutter. I asked you if there were individuals behind you in the line of fire. Yes or no?
Are you talking about the two initial fleeing suspects that ran out of the tunnels with the shotgun wielding individuals?
No, I'm asking if the shotgun wielding individuals fired in the direction of the people who were running up the stairs.
Sure, they were behind me.
Does that strike you as a premeditated plan, Officer Price Cutter?
Yes.
So it's your testimony that these individuals brought a knife to a gunfight, shot at each other, and that all of this was premeditated, deliberate, planned, and targeted?
They didn't shoot at each other. They shot at law enforcement officers. And then the defendant pulled a knife and stabbed law enforcement officers. And Mr. Soap pulled a gun and shot law enforcement officers. And then they all left
But you
together.
testified earlier that they were on opposite directions, firing towards each other. Is that not correct?
No, that's not correct. They were not firing towards each other. They were firing at law enforcement officers.
I understand that it's your testimony that they were aiming at law enforcement officers, but it's also your testimony earlier, unless you got it wrong somehow, that they were on opposite sides. Help me figure that out.
Well, if you look at the exhibits, the tunnel is kind of a wide open area, and they weren't directly behind me. Mr. Soap and Mr. Ward were not directly behind me in the line of gunfire. They were in the area, but the shots were directed towards Dexter Cutter, who was further ahead, nowhere near either of the defendant or the other suspect, and neither of the suspects were directly behind my person.
But you didn't see Mr. Ward, so how is that reconcilable?
I would presume that Mr. Ward was around the corner engaging with Officers Diaz and Stewart.
I see. So I have one more question. Actually, I'm good for now. Thank you.
You're welcome.
Thank you very much, counsel. Your witness, prosecution on recross.
Yeah, one.
Of course.
I would tell you one thing. He is brutal to be cross-examined by. And that's what he does every time, is he asks the same question 10 different ways. He'll come back
nothing
to
further
it.
from the state right now, Your Honor, but we would like to recall, have the opportunity to recall Cali Price at a later time.
Of course, if you could explain why pursuant to the additions to the procedures of the court, please.
Your Honor, given the other testimony we will hear today, there might be further questions we will have for Officer Cali Price that might come to light due to that testimony.
Of course, understood. Yes, not a problem. Yes, Ms. Price, you are free to stand down. However, you will remain under subpoena. You are not free to leave at this time.
I'm actually not under subpoena, Your Honor, but I do plan to stay.
Your Honor,
You
I
were.
would assert that she is under our
Oh,
subpoena.
Quite, counsel, indeed. Yes, you are under subpoena. It was approved.
oh, my mistake. Thank you.
It's quite all right. All right. Thank you very much. Back to council tables with you. Yes. So, State, please, could you present your next piece of evidence or call your next witness, please?
Do we want a
Yes, Your Honor,
brief
one moment.
recess?
Of course.
Why's that?
I don't know. That shit took forever.
I don't need one.
All right.
I figured you're
sure.
gonna ask the next officer the next question.
What do you think we should go with, Logan Graver or Layla Diaz?
I would probably do Layla first, to be honest.
Okay.
Just establish the tunnel some more, establish the fact that one of the suspects was like, oh, but I wanted Dexter cut his back. You know.
Your Honor, the state would call witness Layla Diaz.
Of course.
Can you do me a favor and gray out the ones that are not relevant?
Sure.
Just do it in light gray, or yellow them.
Mm-hmm. We'll do.
Oh, are you gonna take the booth, or are you?
Oh, I can't. Okay.
All right. Would you like an oath or an affirmation?
Affirmation.
You solemnly affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
You can also make them yellow. That's fine.
She's been sworn in.
Thank you very much. State your witness.
Good evening, ma'am. If you could,
Hi.
state your name, rank, and experience for the court record.
Sergeant Layla Diaz with the SASP.
Perfect. Were you on duty March 17th, 2026?
I was.
Do you recall being engaged in a pursuit that stemmed from a bank robbery on that date?
I do.
What was your role in that pursuit?
I was one of the first officers to arrive on scene of the bank robbery, handled hostage negotiations, and was primary in the pursuit, doubled with Dexter Cutter.
Okay.
Your Honor, one little thing. Sorry, I would like to confer with co-counsel for once. It might be in the benefit of the court.
Okay.
What's up?
So the main point of contention for this trial is like the tunnel ambush situation.
Okay.
So I would ask for a sidebar, and if Mr. is agreeable, we can just skip the entire questions about the pursuit, just establish that as a thing. Because he in opening established that his client was present there, and we just ask her about the actual ambush situation and limit the time we have to be here.
Oh, perfect. Let's do that.
Your Honor, counsel would request a sidebar.
Of course. Yes, please. Counsel for the defense.
I apologize. Mr. Murdank is just
Oh,
had
I
some
see.
troubling news, and he'll be.
No,
be
I
a moment to
understand.
collect his
I
thoughts.
understand. It's quite all right. You know what? We'll do a quick recess. Court is in recess for about 2 minutes.
Thank you, Your Honor.
Yeah, because I think it's just going to save everyone the time, because I think we're going to also piss off the judges if we just like ramble about everything.
All right, perfect. So where should I start? Probably down here. Do you recall being involved
I would
in
do
a
that
shooting
with the shooting incident.
I'm so sorry. I'm ready when everybody else is. My apology.
I went in recess for 2 minutes.
No, I heard that. I just, you...
Oh, okay. I don't know if Your Honor, Your Honor, we're ready.
I think he might also be thinking.
Yeah, he had to look at something on his phone.
Yeah, I would probably do. I would go like, what happened when the suspect reached the top of the stairs? And then probably the forensics report as well, just to establish that he was shot.
Okay.
So probably from the stair. Where's the stairs? Probably from like there where I marked in red to just the end of it.
I'll probably how that have been green.
Huh?
Oh my god.
Are we
All
sidebarring
right,
now, Your Honor?
Court's back in session. We are doing a sidebar. Come on down.
Sidebar, please. Yes.
Also, you can sit.
Looks good.
All right. State, you call this sidebar.
Yes, Your Honor. If defense counsel is agreeable, we would just do it so that like the pursuit and everything, yada yada. The main point of contention, if the defense counsel is agreeable, is the situation on the stairs. So if defense counsel is agreeable, we would establish the other things as fact and just limit the matter to that.
Stipulating this. Okay.
Yeah.
Defense. So we do not have to.
Sorry, can I have like a specific description of the like? I'm not necessarily disagreeable to the concept, but I feel like I can't just vaguely agree to stipulate things. I need to know what the stipulations are.
We could.
I feel like that's reasonable.
I think what we could do is give you a moment to discuss amongst yourselves, see what you like, and then afterwards come back to the court with any stipulations you may have, if there are any. Just so that way, you know, the court knows exactly what is stipulated, and we don't go into any awkward positions for information that may not be presented at trial, etc., etc. Is that agreeable with counsel?
Yeah, that's fine. I just need like if there's going to be a stipulation motion, I need to have the details of the motion, and it needs to be in the record, both written and recorded.
Yes. Yes, this is something that I think if you agree to this and then afterwards submit it to the docket, we're happy with that. The court is in any event.
Could you guys just take like 2 minutes to write something up so that I can look at it?
Sure. Yes, that might be for the best. We'll go back into recess, and then afterwards we can again, yes, and then afterwards we can convene and see where we end up. I don't think we'll need a sidebar if you both agree to it. We should be good to go with the stipulation. Flawless. All right.
Yep.
That's all. Apologies, ladies and gentlemen. This court is once again in recess.
Love recess.
All right. So we're doing stipulations of. Hang on. Let me write it down. I'm just thinking. I'm honestly thinking we just want to do the pursuit as the only stipulation of fact.
What do you mean?
Like, we're just going to stipulate that there was a pursuit and the defendant was part of the pursuit and the pursuit went to the subway tunnels, and then we go from there.
I mean, this is already implied by his plea to aiding and abetting, but...
Yeah. Still, I would just stipulate that so we don't have to ask about the pursuits and we can just focus on what happened in the tunnel.
Okay.
I also don't want to stipulate the whole, like, there was a tase and spikes and all that. I don't want to stipulate that because that's just going to put us in a worse position.
Perfect.
Anything else you want to stipulate? I think that's just it.
Yeah, a pursuit that led to that specific platform.
Well, if we do pursuit, then we also have to outline that, like, what happened during the pursuit. I would just say the pursuit went to the subway tunnels, and then everything in the subway tunnel is open through testimony.
I'm letting you lead this charge. I don't understand what you're saying.
It's like if we say the pursuit went all the way to like the platform, then we also have to stipulate like the facts of what happened. Like, I guess it's already on the court record, so we don't really need to stipulate. It's just a question of if we want to stipulate that, like, they got tased and spike stripped and all.
Okay. Oh my god, it's intense being cross-examined by Mr. Murdank.
Yeah, I can imagine.
I did the same thing he always does. He has the same question 15 different ways.
Yeah, because he wants one answer, and if he doesn't get that answer, he just asks the questions a different time. Hi, Mr. Murdoch. I have Bluetooth you the stipulations. They're pretty short.
Did you email them to me?
I did.
All right, sick. I'll look right now.
I'll be
Ms.
willing
Frost,
to tell
can
them that. I could
approach?
clear
Is
it
that
up.
okay?
Sure, yeah, go ahead.
Your stipulation is unfortunately not correct. What, like, we can have Mr. Ward testify. We didn't disclose him as a witness. I don't know if you're going to object to that. But like, he wasn't part of the pursuit. He did go to the tunnels, but not as part of the pursuit. That's part of the issue here. Like, it, I don't think you appreciate the extent to which this was not deliberate, planned, and targeted.
I mean,
Let's
If
just
you want Mr.
avoid
Ward
the
to testify,
stipulation.
I'm happy to have him waive his fifth. Like,
Oh, I would love for him to waive his Fifth Amendment rights.
well, it's just, you know, I'm just thinking about judicial economy, because if we're having like two more witnesses,
I know.
We'll also say the exact same thing of like, yes, we went to a pursuit, and then we went to the tunnels, and then there was a thing on the platform.
I don't think there's any dispute that a pursuit happened. It's just that he wasn't part of it.
He was part of it. He was in the Blue Buffalo Sasquatch. Or Blue Bravado Sasquatch.
2 seconds.
He was the driver of the vehicle. There was a
Yeah, I know.
pursuit.
He'll agree he was in the Sasquatch, but he was not part of the pursuit.
But he doesn't think he was pursued in the Sasquatch.
I don't think so. Let me talk to him.
Did he not think law enforcement officers were pursuing? That's crazy.
Well, if he didn't think he was pursuing, then why did he shoot?
He didn't.
Or why did he stab? Yes.
He was pursued in the tunnels, but not prior to that, if that makes sense.
Yeah, that's fine.
No, do we want to stipulate that?
Yeah, part of a pursuit in the tunnels. I would be happy to have that there.
Okay.
Does that...
How about we just identify him as the driver of the Sasquatch that picked up the other suspect?
That's probably fine. Give me 1 second.
Yeah,
He
that
already
worked.
pled no contest to aiding and abetting.
Yeah.
Driver of the Sasquatch is good. We just want stip that he was involved prior to that.
That's fine.
Cool.
All right.
I never asserted that he was involved prior to that.
I think I did with mine because I said he was a pursuit happened and the pursuit went to the tunnel, but he wasn't part of that pursuit that went to the tunnels. That's what I said in the stipulation. That's okay. So that I think that's the only stipulation we have, right? Marcus Ward is the driver of the blue Sasquatch, and then we just go.
Sure.
Does that work for you guys?
Sure does.
All right, cool.
Do we have to post it to the docket?
Your Honor, do you want us to make a verbal stipulation or post it to the docket?
On the docket, please.
Yes, Your Honor. On.
Kind of feel like all of these questions could have been asked already. But it'll save us the trouble of asking them from other witnesses.
It has been posted, Your Honor.
Just 2 seconds and we'll start. So stip, Your Honor.
Flawless. Oh, sorry.
All rise. Court is now back in session.
As court is back in session, please be seated if you're stood. Thank you very much. All right, so following our recent sidebar, stipulations have been made to the docket so that we can avoid asking the same questions over and over again. These stipulations are as follows. That Marcus Ward was the driver of the Sasquatch that was involved in a pursuit in the tunnels. Would state, is this indeed the stipulation?
Yes, Your Honor. This is just so we can avoid the entire front bit of why were they in the tunnel.
Quite. And defense counsel, no objections to that stipulation?
Yes, Your Honor. We stipulated it on the docket, in fact.
You did. I would like it on this record here with the Associate Justice. Yes.
And
excellent.
now it is.
It is. Yes. All right. So we will continue with the questioning of Layla Diaz. This was the state. So, state, we have your witness.
Perfect. Okay, we can skip a whole bunch of questions now. Ms. Diaz, you recall being involved in a shooting incident on March 17th, 2026?
Yeah.
Where did this incident occur?
In the subway area below Maze Bank.
Okay. What brought you to this specific location?
The pursuit which led from the Fleeca Bank robbery to a swap car into the tunnels where suspects fled on foot.
Okay. When the suspects fled on foot, where did they go?
I recall seeing a suspect flee up the stairs into the upper platform of the subway station.
And what happened when the suspect was at the top of the stairs?
At that point, I recall seeing the two original suspects that we were pursuing in the tunnels. They began running towards the exit, at which point officers became under fire, and those two suspects doubled back and started running back in towards the tunnel.
Okay. Let me see. Did you observe any law enforcement officers being injured on the scene?
Yeah.
Who?
Corporal Dexter Cutter, sorry, was shot down. The two suspects that ran back on themselves, the two suspects that we were pursuing in the tunnels for verification, one of them started bandaging, and the other one, when I turned around, he was stabbing Brendan Stewart, Cadet Brendan Stewart.
And what was your... Oh.
Sorry,
What,
I believe
what
I'm
was
about
your...
to answer your next question.
What was your response to observing...
Yeah, I opened fire on that suspect. That suspect then ran towards me as I shot them and stabbed me.
Were you successful in striking the suspect?
I was.
And where were you positioned at the time of your injury?
At the closer at the top of the stairs in the hallway.
And where was Officer Stewart located?
Practically directly across from me on the other side.
And where was your attacker located?
When I shot him, he was obviously with Brendan Stewart, and he was in front of me at the top of the stairs.
Prior to the suspect stabbing, had you attempted to shoot this individual?
Prior to seeing him stab, no.
Had you attempted to taser this individual?
No.
What were you doing in that moment just before you observed Officer Stewart get stabbed?
At the time, just before I turned around, I was firing at the suspects at the other end of the tunnels.
Okay. Let's review Exhibit 11C, docket line 17.
One moment.
What was that exhibit again, Counsel? Just so we have it for the court.
11C.
11C. Perfect.
Hallway
Thank you.
section 2 in its entirety. Let me know when you have that.
Got it.
All right, in those photographs, are these photographs of the area that you were located?
Yes.
Are these photographs the area that Officer Stewart was located?
Yes.
And is this the area where the suspect that had stabbed yourself and Officer Stewart, is this where he was also located?
Yes.
Were forensic evidence collected in this area?
Yes.
Were reports returned?
Yes.
Please, for the court, review Exhibit 12B.
Thank you.
Please hold.
That's also docket line 17.
Yeah.
Is this the forensic report related to the area where you were injured?
It is.
How many unique DNA profiles are included within this report?
3.
All right. Are you aware of who those profiles return to?
I am.
And who do those unique DNA profiles return to?
Myself, Layla Diaz, Brendan Stewart, and Marcus Ward.
Perfect. And how many unique shell casing microstamps are included in this report?
2.
Did you ever have your weapon test fired for forensic or ballistic results?
I did.
Your Honor, the state would admit into evidence Exhibit 24B. That'll be the test fire of Officer Diaz's service weapon.
Any objections from the defense?
No, Your Honor, no objections.
So admitted.
Perfect. Does your service weapon microstamp appear in Exhibit 12B?
Yeah.
Okay. What kind of weapon was your attacker using?
A knife.
Already asked. Are you able to describe your attacker?
I can't recall. I was more focused on the fact he was charging at me.
That's fair. Were you able to observe any other suspects in the area prior to your being injured?
Yes, I personally recall seeing 2 other suspects.
So how many total suspects did you observe in the tunnels?
I personally can only recall 3.
Okay. You previously testified that you observed Officer Dexter Cutter be shot down. What was his positioning to your recollection when he was shot down?
He was at the other end of the hallway, closer to the exit from the subway station that leads up to Maze Bank.
Okay, give me one moment to confer with co-counsel.
Of course.
Do you have any additional questions that might prove premeditated, targeted, planned intent?
Did you ask her about the Dexter Cutter badge thing? Oh no, that was Logan.
Oh
right?
no, go ask her about that. I don't know if
was
she.
it? Wait, was it her? Who was it again?
I
that
think
said it?
it's
it was it's installed in Locke's affidavit, right? I think I have it.
Yes, and I think Dexter will also testify to it.
Yeah. Okay. Then we don't need. I don't have any other questions.
The state has no further questions for this witness right now.
Thank you very much, State. Defense, your opportunity to cross-examine.
Hello, Miss Diaz. My name is Matt Murdank. I'm representing Mr. Ward today.
I was just being ready to object to
Oh, sorry.
lots
I
of
have a
asked
couple
and
of questions for you. You testified just now that Mr. Ward stabbed you. Is that an accurate description of your testimony?
Yes, I would say so.
And the prosecution asked you about a knife. Is that right?
Yeah,
You remember getting stabbed?
I do remember being stabbed.
By a knife?
Yes.
You saw a knife in Mr. Ward's hands?
I recall seeing a very pointy object which resembles a knife.
Oh, wait, that's so interesting. A very pointy
Mr. Ward's
object.
hand.
A very pointy object. Could it have been a screwdriver?
Your Honor, objection relevance. What's the point of arguing what type of stabbing device it was?
Your Honor, I don't think this could be more relevant, given that the entire case alleges that Mr. Ward was part of a deliberate, planned, and targeted attack on officers.
Yeah,
and
no further arguments are needed. That's overruled. Continue, Mr. Murdoch.
Thank you. Is it possible that it could have been a screwdriver, Ms. Diaz?
I mean, sure, it's possible.
Are you familiar with any long, pointy knives in this state?
I've been stabbed by my fair share, yes.
Well, help me understand. You know what the difference is between a knife and a screwdriver?
I do.
And you know what it feels to get stabbed. Sorry, you'll have to understand the nature of the question that I'm asking. I don't mean to say that you know what a knife or a screwdriver means like inside you, but you know, you look at a knife, you look at a screwdriver. Generally, you can tell what one looks like in someone's hand.
Sure.
Does that question make sense to you?
I think so.
Okay, great. Do you have a strict recollection of what was in Mr. Ward's hand when he stabbed you? Can you say so definitively that it was a knife?
Who cares? She was stabbed.
Can you repeat your question in its entirety, please?
Yeah. Are you 100% certain that what Mr. Ward stabbed you with was a knife and not a screwdriver?
Well, the argument is that he didn't plan
I would
anything
say
because he
I'm
just pulled the
99%
first thing
sure
out
it
of
was
his
a
pocket.
knife.
Okay. And did you happen to search Mr. Ward to confirm that he had a knife? How are you certain that it's a knife?
It looked like a knife. It felt like a knife. No, I did not search Mr. Ward because he got away. I was stabbed.
Certainly. Did anyone else search Mr. Ward?
No, he got away.
What color was the knife that you supposedly saw?
Silver.
Like straight metal all up and down all the way along?
I
Does
just
it
recall
does
a
it matter what
silver
it looked like?
pointy object.
A silver pointy object. Got it. Give me 1 second.
I get what his argument is. He's arguing that, like, because it isn't a knife, it's just a screwdriver, how can it be planned and premeditated? But I feel like he's missing the point of our argument is that he didn't do the planning. He just actively participated in the plan that people with the shotguns had.
I mean,
I
he
think
was
that
well
needs to
aware of
be-
the plan. It was coordinated.
Yeah,
Sorry,
but,
Ms.
like,
Diaz,
it
I'm
doesn't
not really
matter what
familiar with
weapon
like knives in this state. I don't
The
collect them. I
plan
don't
wasn't
carry them, so
formulated
I just
ahead
had
of time.
to,
It wasn't
you know,
even
get
formulated
some
when he
understanding from an expert.
arrived at the
I
tunnels
hope
to pick
you'll
up Mr.
appreciate that.
Soap.
We
It
can
was
actually move
formulated
on,
as they were fleeing in
from
that
what he was holding.
Sasquatch.
Brilliant, thanks.
Yeah, my pleasure. My pleasure. I'm not trying to re-traumatize you or anything. It's just, I hope you'll understand we have to make a factual record. So this dispute that happened in the tunnels, do you have any evidence to support the claim that Mr. Ward engaged in deliberate, planned, and targeted conduct?
One more time for me.
So do you understand the charges being pushed here today?
I do.
And you understand that they're first degree and that that's different from second degree?
I am aware.
And do you understand how they're different?
Yes.
And you understand that first degree requires that the alleged acts be deliberate, planned, and targeted?
I do.
What evidence do you have that Mr. Ward engaged in deliberate, planned, and targeted conduct?
She's not the investigating officer. She also didn't push the charges. Can we formulate an objection and save her?
I would say, given the fact that Mr. Ward very well could have continued running out of the subway exit, rather than double back and proceed to stab an officer and myself, when he had a straight run to the exit of those tunnels, he decided that he wouldn't do that. He would turn around, target another officer and myself, and attack us.
He was running towards the exit originally, though?
He started to, and then he turned around, yes.
I see. And in your experience, is it consistent with people who have deliberate plan? Actually, have you ever otherwise been subject to something that you allege was deliberate, planned, and targeted?
No, I don't. No.
What do you think of that
I'm
question?
gonna go with no.
So you don't have
I
any
don't
other
know.
experiences to compare this to that you know maybe had resulted
What do you mean
in
you don't
guilty
know?
pleas or something like that? Nothing else that's comparable?
What do you think of what question? Did
Not
you
of
write it?
attempted first degree.
If
no.
I ask if he turned around
And
before
were you
or after
responsible
shots
for
were fired?
determining which charges should be pursued
Yeah,
in
I
this
think
case?
that is pretty relevant for us to clarify.
If you were responsible for determining which charges should be pursued in this case, would you have chosen first degree?
You better say yes. I swear to God, if she doesn't say yes.
Your answer, please, Miss Diaz.
I'm just thinking on my articulation. Give me a second.
I swear to God, is she gonna throw me under the bus?
So you don't have articulation prepared today, is that right?
I was not primary on this instance. Somebody else was.
But you can't
and
say it
therefore
offhand
the
either.
charges, Therefore, the charges were not my decision to make.
So you can't testify offhand right now what was deliberate, planned, and targeted about this?
Like I just said, I would say it's a very deliberate act to not continue running towards the exit and instead double back to attack officers. But I am not going to sit here and say that I would have made a different decision on charges for a scene I was not primary on.
I understand, Miss Diaz. I understand. And in your experience, you said you've been shot a number of times?
Yeah.
And stabbed?
Correct.
And in your experience, do people usually bring screwdrivers to gunfights?
They have.
Screwdrivers? Question mark.
You know, if there's going to be a gunfight and someone wants to participate in it, do they usually bring a screwdriver?
They bring any
I've known
number
many
of weapons.
suspects to stab.
Could you answer the question, yes or no?
Yes, people bring
I'll
all sorts
ask
of
it again.
weapons.
Yeah,
yes, certainly, Miss Diaz. If someone knows they're going to participate in a gunfight, in your experience, do they bring a screwdriver?
I don't believe it was a screwdriver. But no.
I'm asking
not.
you about your experience, Miss Diaz. Can I get a yes or no, please?
Typically not.
All right. And how about a knife?
Typically not.
What do they usually bring?
To a shootout, a gun.
Did you ever witness Mr. Ward in possession of a firearm?
I did not.
Did he shoot you?
No, he did not.
Did he shoot anybody else?
Not that I recall.
And who shot first?
Suspects.
Which ones?
The suspects that were at the other end of the tunnel.
Shooting in the direction of Mr. Ward?
In the direction of Corporal Dexter Cutter.
Is it approximately that? I mean, the tunnel goes two ways. Were they shooting away from Mr. Ward or towards Mr. Ward?
Initially, they were shooting away from Mr. Ward.
I would guess towards.
Have you ever staged any shootouts yourself against suspects?
No. No, please.
Not
Have
that
you
I
ever been
recall.
part of a felony stop?
Once I've had the privilege, yes.
And you're trained on felony stops?
Correct.
How is a felony stop positioned?
Objection.
Yes.
The state would say that this is out of scope.
Your Honor, it's relevant to how officers determine to shoot. The shooting is
on scope. Want to articulate that part?
Yes, I was about to get there, Your Honor. The shooting is part of this conversation. I'm about to finish the point. It's a matter of how decisions are made about when and where to position and shoot. And in this case, there's
no. I see where you're going with this. Yes, overruled.
All right, Ms. Diaz, how are officers positioned
I'll
during a
say
felony
that a
stop?
felony stop is substantially different.
In an arrow formation.
And why is that?
Officer safety.
Tell me more about what officer safety is at issue, perhaps in the context of shooting.
Doesn't have to be a very good
Do
plan.
forgive me if it's very late for me right now.
It's completely understandable, Miss Diaz. Why do officers form in an arrow when there is a felony stop?
It's going to take you like
So
cross.
officers
You know
have
what?
line
What
of
officer
sight.
say? There
so that
we go.
officers have line of sight.
Is part of that purpose to ensure that officers don't shoot each other?
Yeah.
And if you were to stage a shooting, would you ideally make sure that officers were not on opposite sides of that shooting?
It's preferable.
And that would be part of a plan that you would make?
Where possible.
Have you been part of planned shootings in the past where individuals were on opposite sides of each other?
I've been involved in shootings where individuals were on opposite sides of each other.
That's not what I asked you, Miss Diaz. Planned shootings.
No, I don't plan to get into shootings.
Good enough. Thank you, Miss Diaz. That's all, Your Honor.
Thank you very much, Counsel. State your opportunity for recross.
Yes. One moment.
Yes.
Of course.
Okay. We should definitely argue that like plans don't always happen like hours beforehand, and there's definitely situations in her personal experience where like due to the situation changing, the plan the plan has to be made like on the spot, and that premeditation doesn't require the plan to be made hours prior. And also just drive down the point that like criminals aren't trained shooters. So I don't see why the argument should apply here. Like obvious, there is friendly fire in criminal situations.
Okay, I'm gonna ask my 2 questions, and then you. Is that all right?
Sounds good. Yeah.
Just a couple of questions for redirect.
Of course.
If I may, Officer Diaz, at what point in time did the suspect Marcus Ward turn around during this incident?
After he turned around after shots had begun to ring out.
Okay. And Officer Diaz, you have specific training and experience for how to conduct a felony stop?
Yeah.
You have specific training experience for how to handle firearms?
Sure.
To your knowledge, do criminals have any specific training and experience?
No, not beyond the situations they find themselves in.
All right, one moment, please.
That sounds good. I'll just ask about the plan.
All right, perfect.
Officer Diaz, hello. Officer Diaz,
Hi.
have you ever made a plan for some?
Sorry, you. I didn't hear your question in its
Oh,
entirety.
sorry. Have you ever planned something?
Sure, I've planned things before.
Do plans always require like hours of planning beforehand?
No.
Have you ever experienced in your personal life or in your professional experience that plans can just be made on the spot?
For sure.
Officer Diaz,
Do you have one?
have you ever had a plan that didn't work out?
Yeah, I've had a few of those.
I think that's all. We have no further questions.
Fantastic. And defense, your opportunity for your last cross. I don't want to get into
Your
back and
Honor,
forth.
you know, I could, but it doesn't feel efficient. Thank you so much, Miss
Oh.
Diaz.
Mr. Murdoch, a man after my heart. Thank you so very much, Ms. Diaz. Does any party intend on recalling this witness?
I don't think we need to. We don't have anything else.
Not from the state.
Defense.
Nothing further for this witness, Your Honor. We're so grateful to Miss Diaz for her time, and we hope she enjoys the rest of her evening.
Fantastic. Thank you very much, Ms. Diaz. You are released from the terms of your subpoena. You are free to go. However, you may stay for the remainder of these proceedings if you would so wish.
Thank you.
All right, state onwards. Please present your next piece of evidence or call your next witness.
The state would call Officer Dexter Cutter.
Good luck.
That's crazy, do you
Mr. Dexter Cutter, nice to see you. Good news,
Hello.
everyone. His sanction has been lifted, so we're all in happy spirits. Yes.
I'm
Thank you so
thrilled to
much for
hear
your
that, Your
attendance.
Honor. I love to
I'm
see people
sorry.
attend court.
Indeed, indeed. All right.
All right. Would you like an oath or an affirmation?
Either one's fine with me.
All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. He's been sworn in.
Thank you very much. Your witness, state.
Well, there. Your name, rank, and experience for the record.
Corporal Dexter Cutter with the San Andreas State Police. I don't know my exact time and thing, but 6 months to a year, something like that.
All right, perfect. Do you recall being on duty March 17th, 2026?
Yes.
Your Honor, a quick objection. Actually, can we sidebar?
We can, yes.
Oh. I know what he's going to do. He's going to object.
Your Honor, we have a strong objection to an individual questioning their spouse as a matter of conflict.
Are you married to Mr. Cutter?
Yes, that is
their
my
names are
husband.
Price Cutter, Your Honor.
No, but I do note it. However, I'm sure there are more than one person called Blackstone on this planet. Certainly not in this state, however. Yes, in that case, I completely agree with defense counsel. Although the previous statements won't be withdrawn from the record or stricken from the record. That is, they're rather benign questions. So
Yeah,
I
that's
suppose
fine.
we can. Yes, I suppose
It just took me a second to
yes.
figure out that this was happening.
I thought that, and I was like, I did raise an eyebrow. But thank you for bringing this to my attention, Councillor. Yes, indeed. Ms. Frost, this would need to be your witness. I will say, however, Ms. Price, you are allowed to object, etc. That's perfectly fine. It's just, as Councillor Murdoch highlighted, questioning is rather another thing altogether.
Oh, that's perfect.
Outstanding.
There are
All right.
4 other Blackstones in the state.
That's crazy.
My family. I've never met any.
Can't
of them.
wait for
Anyway.
the reunion. Send pictures.
Yes, I'll be sure to send everyone an invite that's here. All right, everyone. Thank you very much. Back to places.
I'm just going to establish he was on duty and then jump straight to the green question.
All right,
Sound good?
perfect. The most important thing for him was
Councillor Murdoch raised a concern,
the
and that has
suspects
now
that
been
were
addressed,
approaching from
and
the
now,
stairwell,
Mr. Dexter
where they
Cutter will
came
be
from, what were they
questioned by
doing,
Ms. Diana Frost once they are
observing
so they will have
suspects
the
on the
opportunity
radios.
to,
Yeah, all
discuss
the
with
green
them.
questions, right?
And also if he heard anything.
Okay, you want to just add that at the end? Awesome. All right. Ready? When are you on?
All set.
Fuck him up.
Apologies again. Were you on duty 17th of March 2026?
Yes.
Where did the suspects go after they exited the Blue Sasquatch?
Once they exited the Blue Sasquatch, they started running up the stairs of a subway exit.
What happened when the suspects reached the top of the stairs?
Once we reached the middle hallway level, I ran in front of them just to make sure that nobody was sitting there waiting for us.
Did you ever observe either of the suspects using their radio?
Yeah, multiple times between the point of them exiting the vehicle to the point that I ran past them towards the final staircase that leads out to the street.
Were you able to hear what was being
No, I do not recall.
do you recall any communications from law enforcement officers during the pursuit at this time?
With how hectic it was, I do not recall hearing anything on the radio myself.
When you approached the upper platform stairs towards the exit, what did you observe?
The moment I rounded the corner, there were two men standing at the bottom holding shotguns.
How were you positioned at that time?
I ran in front of the two suspects we were chasing, so a jog / light run straight to that corner where I was met with shotguns.
Were the two suspects with the shotgun already in the area, or were they still on the stack?
Oh, they were at the very bottom. So about to round the corner.
And they opened fire. Did they open fire immediately?
Yeah, right away. The moment they saw me, I got shot with the shotgun.
So the firing line at that point you would have had a wall behind.
Sorry, one more time?
Did you have a wall behind you or not?
Oh, the way that they had shot towards me, yeah, there would have been a wall behind me.
And there was no one else in the line of fire?
You cut out one more time.
There was no one else in the line of fire?
Nope, just me at the moment.
Did the suspects relay any information to you? Did they say anything?
From the moment that I was shot down till they left, nobody talked to me.
Were you able to return fire?
Yeah, I was maybe able to get maybe 3 bullets out of my gun.
Were you injured at this time?
Yeah, yes, definitely.
Were you conscious at this time?
For a short time, yes.
Were you able to observe anything else?
I witnessed the 2 people with shotguns run past me. I didn't really get to see the big back and forth past me, but I did hear a lot of shotgun noises and the sounds of what would I assume be some kind of blade or something, some kind of like stabbing noise. I don't know how to explain that properly, I guess.
Did you hear the suspects express anything as they were leaving?
No, not that I recall.
Do you believe the suspects you encountered were involved with the fleeing suspect?
Yes, definitely.
Why?
Well, from what I remember, both of the 2 suspects coming down the staircase were wearing a light blue, what I assume was a CB mask.
And they all left together.
One moment. You have anything else?
Just he said he observed the 2 people with the shotguns running. I want to know if they all left the same direction. All of the suspects on the scene.
Okay. All right. So. Hello again.
Hi.
Did the suspects all leave in the same direction?
That I don't recall. I was on the floor bleeding.
I understood. One moment, you're on. I believe that's everything, right?
Yep, that should be it.
It's everything for the state right now, you're on.
Thank you very much, Counsel. Counsel for the defense, your witness.
Hello, officer. How are you today?
I'm okay. How are you, Mr. Murdank?
I'm pretty good, Mr. Price Cutter. I just, I'm gonna try to keep this quick. I know you heard everything else that got asked, especially of Miss Diaz. So hopefully we can just run through some of that with you as well, okay? Sure. You just testified that you were shot by the individuals who came down the stairs.
Yes.
Is it your testimony that those were the first individuals to shoot?
Yes.
And are you familiar with the charges of first degree and second degree murder?
Yeah.
Are you familiar with the differences between those charges?
Good amount, yeah.
What about this was deliberate?
For me personally, as far as that goes, is they were there, right?
Sure, that's a great answer. Thank you, Mr. Price Cutter. Second question: what about it was planned?
I guess I don't really have an answer for you at the moment.
Thank you so much. What about it was targeted?
No
That
answer
is
for it.
terrible.
Thank you so much.
Yeah,
I have a couple more questions just about
not
what
that
actually
great.
happened. You were chasing Mr. Ward and one other individual, is that right?
Yes, sir.
And they were ahead of you going up the stairs, is that correct?
At first, yes.
At first? Wow, that's the next thing I want to ask you about. Then what happened?
I ran past them.
And how were you able to do that?
How was I able to run past them?
Yeah.
Well, I believe at the moment they were running around in circles, tackling each other.
Tackling each other?
Tackling officers, or I believe there was a lot of tackling going on.
A lot of tackling going on. And did you observe one of the individuals to be injured?
I do not recall.
You didn't see the individual. Sorry, did you see the individual who didn't have an arm?
Yes.
Did you pay attention to his gait or his pace?
No.
To his what? Sorry.
The way he walks. Let me use a different one. How fast he walked, the way he walked.
In that moment, I don't recall. That's just me not remembering off the top of my head.
All right. Let me put it to you this way. Individuals who are attempting to flee from the police, typically, do they run at a consistent pace away from you?
Yeah, most of the time, not always.
And if they had kept running at the same pace, would they have stayed ahead of you?
Yeah.
And if you hadn't been able to catch up to them, would they have tackled you?
Sorry, you cut out. Can you say that one more time?
Oh, I'm so sorry. If they hadn't, if you hadn't been able to catch up to them, would they have tackled you?
Your Honor, objection, speculation.
Your Honor, this is a matter of physics.
Well, the objection was speculation, yes?
Yes, Your Honor.
And what? Apologies. What was the question again? Just so I can confirm. I think it was. Were they?
If the officer hadn't managed to catch up with them, then they wouldn't have tackled him.
Yes, sustained.
Mr. Price Cutter, do you often get tackled by people that are far ahead of you?
No.
You ever been tackled by someone who's 20 feet away from you?
Can't say I have.
How far away were they from you when you were originally chasing them up the stairs?
Yeah.
About 5 feet or so. 10 at the most.
All right. You ever tackled someone 5 or 10 feet away successfully?
Can't say I have.
Would you be afraid of them tackling you from 5 or 10 feet away?
Afraid of them? No, not of that. No.
And so, if they were consistently 5 or 10 feet away from you the entire time, could they have run up the stairs and gotten into the car?
No, because they stayed back running around in circles.
If they had been 5 or 10 feet ahead of you the entire time, could they have run up the stairs and gotten into the car?
Oh,
yes.
Yeah, then yes.
Thank you. And did you personally see this running around in circles?
Yeah, yes, that's why I was able to run past them.
how many circles?
Yeah.
You don't remember?
No, I was too busy running past them to count how many circles they were running around.
Certainly.
good
And
answer.
do you remember what they were doing while they were running around in circles?
Running around in circles?
Did
I
you
might not
notice them?
understand the question.
Yeah, that's fine. I was going to rephrase it. Did you notice them doing anything, perhaps with their hands while they were running?
I mean, other than tackling, that's pretty much what they were running around in circles tackling.
Did you witness one of the individuals
No.
With what, sorry?
bandaging themselves? Did you witness one of the individuals bandaging themselves?
He did not.
I do not recall.
You don't recall. That's okay. All right. And have you ever been part of any planned shootouts
No.
on either side?
Oh, yeah, I guess on the cop side I have.
Tell me more about those.
To be honest with you completely, it's been a while since I've been in a planned shootout to recall one off the top of my head.
Do you remember how folks typically position themselves for those shootouts?
Yeah, roughly.
Could you maybe describe what they do and don't do?
Well, they sit in a spot and wait for people to walk up on them, I guess.
Could you describe how they do and don't position themselves? I hope you see where I'm going with this, Mr. Price Cutter.
Well, usually you have suspects lead officers to a specific location where other people are there waiting, and then the moment everyone's arrived on that location, gunfires ensue.
And are the guns typically aimed at opposite directions? By the same, affiliated parties?
Not that I've seen.
Would you ever want to be downwind of another officer's shotgun or pistol?
No.
And in this case, you said that you got shot and then you heard more shots. You were positioned near the start of the tunnel. You said you had a wall behind you. Do you know whether Kelly Price had a wall behind her when she got shot?
I have no idea.
Yeah, those two questions.
You have no idea. All right, thank you. One more second. Thank you very much, Your Honor. We're all good.
Outstanding. Thank you very much, Defense Counsel.
Yes, Your Honor. For question. Were you tackled?
Me personally, I was not.
Have you ever been tackled by someone that was running and then turned around to tackle you?
Yes.
Do you believe the suspects planned for you to run ahead of them?
No.
Could they have anticipated that you could have run past?
Anticipated possibly, but I don't think so in this instance.
If you had not run past them, would that not have ensured that the line of fire was one clear situation?
Yeah, I'd say so.
Beautiful.
I think that's everything. Huh?
Yep.
Your Honor, once again, in the interest of efficiency, we're going to waive recross.
Flawless, Councillor Murdoch. Thank you so much.
Do we need him? We don't need to
Is there no
recall
further
him.
questions? Apologies. I didn't hear that from prosecuting counsel.
Yes,
Unless
no
you're
further
confirming.
questions, Your Honor.
Oh, apologies. Okay, I didn't quite catch
There's also
that.
no reason to recall this witness.
Flawless. And defense, do you intend to recall this witness? Or call this witness, I suppose?
Mr. Price Cutter, we hope you have a wonderful evening.
I take that as a no. Thank you very much. You're
Have a good
released from
night.
your subpoena. Yes, take care. Counsel for the prosecution, please present your next piece of evidence or call your next
Graver,
witness.
right? Then.
Yep, Logan Graver.
Yeah, it's the last one.
Your Honor, the state would call witness Logan Graver to the stand.
Would you like an oath or an affirmation?
Both, please.
You swear to
We
tell
do
the
have to
truth,
go over the
the whole
pursuit with
truth,
him because
and nothing but the truth, so help
they
you
were
God.
pursuing from
I do.
above ground.
He's been sworn in.
Thank you very much. Prosecution, your witness.
You want to do 'em?
Sure.
Right, so
Hello there, Mr. Graver. If you could, for the record, your name, rank, and department.
Logan Graver, Officer, San Andreas State Police.
Were you on duty March 17th, 2026?
Yes.
Do you recall participating in a pursuit that stemmed from a fleet of bank robbery?
Yes.
And what was your role within this pursuit?
Co-pilot of Air One.
Okay. As a co-pilot of Air One, did you observe the vehicle enter the tunnels, the pink growler?
I did.
What did you do after that pink growler entered the tunnel?
We called out to officers where they entered over at Mission Row. We then proceeded to fly to known tunnel entrance/exits in the event that they came out one of them.
Okay. And did you see anything at any of these entrances?
As we were proceeding west over the city, we eventually saw a blue Albany V-Star trailing our position.
Okay. And where did this blue Albany V-Star come from?
The east side of the city.
And where did it go?
To the pedestrian entrance in front of the Maze Bank over in the Morningwood area.
Okay. Do you recall if you relayed any information to other law enforcement officers about your observations?
Yeah, once we saw the vehicle trailing us at a high rate of speed, we called out that it's possible interference. And then once they parked at the pedestrian entrance, we advised them of 2 individuals exiting the vehicle with shotguns.
Okay. I don't need to ask those questions. About how long was the vehicle present before the individuals exited the vehicle with those shotguns?
Seconds.
Okay. Let me see. Did you remain in the air unit?
After the individuals entered into the tunnels and opened fire, my pilot made the decision to land the helicopter.
And what happened when the helicopter landed?
At least 2 of the suspects came up top and opened fire on Air One, with us still inside, and at that point we returned fire.
Okay. Are you able to affirm whether or not you struck any of the suspects?
I believe I did.
Were you injured at this time?
I was.
Did you observe anyone else to be injured at this time?
My pilot.
Give me 1 second.
ask him if he heard anything from the suspect.
Oh, yeah.
If Sterling heard it, he might have heard it.
Go ahead and ask it.
Other than that, I don't think we have anything else because it's he's just there to like establish that the car was there.
You want to ask that?
Yeah, sure. Hello, officer.
How are you?
Did you hear the suspect saying anything as they were leaving the scene?
I did not.
Okay. Did you hear them say anything as just during the entire?
No, I was not close enough to generally, I guess, have a conversation with them. They were busy shooting at me.
Thank you this time.
Thank you very much, counsel. Defense, your witness.
Hello, Mr. Graver. How are you doing today?
I'm all right, sir. How are you?
You know, I'm doing pretty okay, all things considered. I'm going to try to keep this quick. I know that we've all been here for a while. I will ask if you've been here the full time to hear the questions asked earlier.
I have.
And did you hear the discussion about Mr. Locke's affidavit?
I believe so, yeah.
All right, wonderful. So there were some questions that I asked earlier about your testimony versus his. And I believe that he stated that there was a straight shot from Maze Bank to the tunnels or something. Anyway, there was a straight shot of some sort. We can go back if we have to.
Sure.
And you stated that they circled. Now, Ms. Price, I'm not going to testify about that, but Ms. Price gave some testimony earlier, and the court may or may not decide whether she was able to reconcile that. But perhaps you can help us reconcile.
Sure.
What gives?
So I think maybe the miscommunication there is that Air 1 started circling tunnel entrances. The V-Star that we witnessed was directly going from wherever they came from to that entrance that they
Wonderful. And so it's your testimony today that the V-Star was not circling.
The V-Star was not circling. It was point A to point B.
Wonderful. And are you did you hear the questions asked earlier about the charges at issue today?
I did.
Wonderful. And do you understand the difference between the charges, first and second?
I do.
What about this was deliberate?
I would argue the action that the V-Star took to get to the other suspects.
Okay. And what about it was planned?
I can't speak for their planning, but the fact that they
Nope, that's
spelled
fine.
them-
That's fine. That'll do it. And what about it was targeted?
Well, nobody else was chasing them, so it had to be against us.
That's interesting. And does that mean that your testimony is that you were shot because you were chasing them?
I don't know why I was shot, officer or Mr. Attorney. You're gonna have to ask them.
Certainly. Let me rephrase that. Does that mean it's your testimony that you wouldn't have been shot but for chasing them?
I can't speak to that.
All right, that's fine. That's fine. Mr. Graver, have you been in a number of chases?
Fair amount.
And you've been in chases that haven't ended in shootouts?
Correct.
And you've been in chases that have ended in shootouts?
Correct.
You ever decided to pursue aggravated attempted first-degree murder charges?
I have not.
Why not?
The situation didn't call for it.
Do you believe the situation here calls for it?
I can see why it would be.
It's not what I asked, Mr. Graver.
Yes.
Why?
I think the deliberate stalling of the suspects in the tunnels to wait out for their compadres to arrive argues that they had chosen, instead of to leave the tunnels, to stay there and cause the shootout.
But you didn't see them stalling in the tunnels?
I did not know, but based on
so the only information you have that they were is it true that the only information you have about them stalling comes from other people
at this time?
So you're not aware that there might be a possible alternative explanation for why they weren't as fast as the officers?
I wouldn't argue it.
But you don't know whether there is or isn't another explanation?
I do not.
And you can't say so definitively that they were stalling?
I cannot.
Wonderful. Did you see... Sorry, let's see.
No.
Give me 1 second, Mr. Graver. I'm going to try to be quick.
Mm-hmm.
All right, last question, Mr. Graver, or last couple of questions, hopefully.
Sure.
When you've been part of chases that haven't resulted in shootouts, how have they gone differently than this one?
Generally, it's whenever it has happened, there's been a foot pursuit at length, and no other vehicles present. It's generally they run until they round a corner or feel like they can no longer get away.
And if a second vehicle shows up on scene, is that necessarily indicative of a shootout?
No, generally it's more so of a pickup esque, where they'll attempt to get into the vehicle to then flee from the officers on foot, as they'll be able to get distance from officers.
Can you say for certain that the individuals here plan to engage in shooting?
I can say for the two that came in from the tunnel, not of the two inside at the time.
How do you know that for sure?
Well, when you get out of a vehicle and run with your shotgun drawn down towards officers, there's not many options.
When did they make that decision?
I would assume before they even got in the car to go over there.
You would assume?
Well, I'm not them. I can't speak for them directly. But if you're
So
gonna bring a
you
shotgun,
don't know whether you don't know whether or when they made a decision to shoot?
No.
And you don't know whether or when they made a plan to shoot?
No.
Thank you so much.
I think we need to clarify that they definitely made a plan whether to
I
shoot.
trust no further questions, Councillor.
Certainly, Your Honor.
Outstanding. Counsel for the
You can-
prosecution, your opportunity to redirect.
I don't know that he can answer that question.
Yeah, fair. I don't think we have anything for him to do.
Yep.
No further questions, Your Honor.
Fantastic. Does either party intend on calling this witness in the future, or
Not for the state, Your Honor.
defense?
We thank and excuse Mr. Graver.
Do you have anything you want me to ask?
Thank you very much for your testimony, Mr. Graver.
After
You
all
are
this,
free
or
to
we
go
just
for your
relieving you?
subpoena.
For Your Honor.
Counsel for the state, please.
Yes,
call
Your Honor,
next
one moment.
witness.
The state would first like to summarize and point out the consistencies between testimony of Logan Graver
Your Honor, objection.
and
Counsel's testifying.
affidavit of Sterling Locke.
Counsel can do that during their closing statement, rather than during their case in chief.
Your Honor, for the
Uh-huh.
record, is the objection sustained?
What was the objection? Counsel is testifying. I didn't hear any testifying at that point, so I'm going to say overruled. But I didn't hear anything in that regard at that time.
Do you have any questions still for yourself? Like, do you want me to ask anything, or are we good with you?
For the avoidance of doubt,
The only
counsel,
other
you are
thing would
encouraged to do
be
so if
the
you
ballistic
believe it pertinent
reports.
during your closing statement.
Okay, but do we need those for Marcus Ward?
No.
Okay, so if we have nothing further than that, do we have anything else we need to submit or call? We don't have any other witness.
No, I think
So, are we
should
recalling you,
be
yes
good.
or no?
No, I don't think there's any need.
Your Honor, the state would like to thank Kelly Price for her testimony. She will obviously stay here as counsel, but we will not be recalling her as a witness, just to ensure that the subpoena is lifted.
The defense is going to call
Unfortunately,
me.
it's not your subpoena, counsel. It is the defense's subpoena. So it is unfortunately not yours to lift, I'm afraid.
Understood, Your Honor.
Is there anything further from the prosecution?
Do we have any other evidence to support?
Let me review the evidence. We'd just like a
We're just
moment to
reviewing the
review the
evidence
evidence.
Of course.
I find it. I mean, I don't want to be an ass, but I find it strange how we were only given 3 subpoenas, but defense was given
Would it
4.
at all be
You know how-
beneficial for the court to go through the evidence which has not been admitted, or those that have? Been
Your Honor,
admitted?
we would object to that. We would assert that the state has the burden of doing that. I appreciate the court's intention, though.
I'm trying to expedite these hearings. Unfortunately, I'm trying to get everyone out of here as quick as we can. But yes.
Gives crime scene photos, states or forensic report. Doesn't matter. The most important ones are the OIS crime scene photos, the forensic reports, the DNA on file, which has been submitted.
Have we submitted the alpha alerts? I don't think we have. I think we should submit those as well, just to
Okay.
establish that there were 6 officers shot.
Perfect.
Your Honor, the state would like to submit Exhibit 2 in its entirety on line 7.
Any objections from defense counsel?
Just a second, Your Honor, to look. No objections, Your Honor.
Do we have 8, 9, 10, 11, all those in?
I saw that shit.
And 12, 13, too?
8, 9, 10, 11.
Anything further, prosecuting counsel?
You could just ensure.
Your Honor, could we perhaps have the bailiffs investigate the gas-related occurrence that seems to have just happened? Maybe a recess for that to happen?
Beg your pardon?
Did you not see the gas situation?
Your Honor, he seemed to have dropped his cougar spray on the ground.
Oh, I didn't see that. Luckily, I was looking at different evidence. Does anyone feel
Your Honor,
like
should we be concerned for
yes.
safety?
Yes, I think fair point. Yes, court is in recess briefly. If the
Someone get a
Department of
fan.
Corrections could investigate that, this also gives the opportunity for the prosecuting counsel to get themselves in order. Court's in recess.
Stretch
Does anybody have like a fan? Can we like air it out in here?
Hi, Pookie.
Yeah, I'll just confirm if 8, 9, 10, 11, 12, 13, 49 evidence.
He did it.
And
This
I
guy
think
did it.
We definitely have the affidavits in there, so that's not a big deal. And the forensics evidence we don't really need today for Marcus.
Hi, gorgeous.
Do we want to go back and call me
Arrest him.
and establish Exhibit 20?
How you doing?
I don't
What
know
is
how we would
Exhibit?
do that. That's the affiliation, the individuals that are all involved.
Yeah, I
DNA
honestly
will come from the same-
don't know
What's
how
that?
we're gonna do that, and I also don't know if it's like super relevant to this matter.
All right, that's fine.
Like it's gonna help us obviously if we're like to prove that they're all affiliated, but I feel like there's enough testimony that's been like, oh, they're the same gang, same color.
All right, that's fine. So I just want to ensure that Exhibits 8 through 14
Mm-hmm. Yeah, that's in.
and 21.
What's 21?
Marcus Ward's MTT mugshot. It doesn't matter. He's already identified himself. It's
Isn't it the same as isn't it the same as 14? Though? Don't you have it as 14?
No, that's just his DNA on file.
Ah, okay.
But it's not relevant because he's already identified himself as
Yeah,
being
he's
the
already
driver.
identified himself.
He's identified with DNA on the scene. It was the stabbing suspect.
Yeah, we're just gonna do 8 to 13. 8 to 14, just to be safe.
Cougars. That guy right there, ripped ass.
Wow, Mello Kandinsky's here? I wonder how he's doing.
That's crazy.
You look weird.
I don't think that person's here.
Oh, no.
I didn't say good.
I was gonna
either.
say
I just said you look
she
weird.
was scared.
Damn.
Wearing them.
Yeah. Who doesn't like some eggnog?
I don't know about that.
He's not. What?
It's gotta keep that shit tight. You don't want to let the guns out. Also, I don't wear ties. I don't wear ties. I only let pretty ladies strangle me. No, 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 no. You shouldn't do that. I'm gonna tell them you're assaulting me. I'm gonna have you arrested like that. The fucking guy over there just ripped ass.
That's
Rip
true.
ass, is that why it smells so bad?
Yeah, that's what I call.
Oh, that's why my eyes were stinging.
Yes, we are.
Yo, Murdank.
Both. They both don't like it.
So.
Got any of that extra
so-
Murdank on you, bruh? I'm trying to.
If they call Hazel,
oh my god,
I don't have anything for Sam Gubasali, but if they call Hazel, to, like argue like, oh, you're pushing charges like unfairly, I would then bring in 2025 CM 211, which is where they pled no contest to 7 counts of first-degree murder.
Did I push those charges?
You did push those charges,
Oh, perfect.
and they all pled no contest to those.
No. I've just been
Make
here
room for
3
Hazel. I have
hours.
to
had
feed
no
her.
way to make that back in my life.
Do you need beverages?
Yes, please.
What?
Stephen Burgess of Cypress Bravo.
There you go.
No, I can't do that.
Is that
Yeah.
helpful?
I'm Steven.
Fish can't be named. I can't.
That is
Please don't pass out in my courtroom. Thank you.
And Archer Burgess, who's in the black headband.
Can I pay money to overwrite somebody?
Why are we snitching? Okay, let's just not. Nobody
Why do they
needs to
have
know
be
anybody's
yelling?
government
I really
names,
don't care
okay?
about this conversation over there. Yo,
Can you hear them?
yes.
I love how they're calling themselves out, knowing that they have warrants, but that's fine. Well, I don't think
that
they
makes
know.
sense.
I think they think they know. I think that they think they have warrants, which is why they're doing it.
That chick's
Mm-hmm.
bad.
Because we've referred to
That driver's license. is fucked.
like multiple DNA
I
in
caught
this
that
trial.
shit.
Well, at least you know if you
No,
bring in
I
the
don't think
charges
she's
against
present.
them, you know
I don't think
after
she's
this
here.
trial what charges.
This has honestly been a
No, look,
roller coaster.
Yeah, I am very happy
this is
when
no
we.
facial hair.
Oh, that person went to speak to.
I mean, yeah, it would be a little darker around the lips.
I don't
the
understand why
chin,
Murdoch
yeah.
was pushing so hard over the fucking screwdriver or knife scenario.
It's
Like,
just because he's like his argument's gonna be that like how is it planned if the person just pulled the first thing they had out of their pockets to defend themselves or like to do whatever they want. That's the argument here. That's why they're pushed so hard.
Oh, I'm gonna go.
Thank you
Mhm.
very
Here
much,
comes
bailiff.
Katrina.
Court is back in session. Now we were on to the prosecution for anything further to submit. Prosecuting.
Yes, Your
counsel,
Honor.
anything further?
Prosecution on line 17 would submit 8 to 14 all in its entirety if they have not been submitted already.
8 through to 14.
Yes.
The only one that I have here is Exhibit 10A. Defense, any objections to Exhibit 10A?
That's fine, Your Honor. No objections.
With that, that's admitted. And
then we rest our
afterwards,
case.
Anything further?
Perfect.
I believe we also have a 9B, just for the avoidance of doubt. That one's not highlighted on my notes, so we'll. Any objections from the defense on that one?
No objections to that whole batch, Your Honor. It's all fine.
Flawless. Thank you very much, counsel. Anything further from the state?
State has nothing, Your Honor. We rest our case.
Duly noted. Defense counsel, your case in chief.
We call it Hazel Rossi, Your Honor.
Absolutely. Ms. Rossi, please.
would you like an oath or an affirmation?
Affirmation, please.
All right. Do you solemnly affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
She's been sworn in.
Thank you.
Ms.
very
Rossi,
much.
would you please make sure you're speaking at the top of your lung?
Yes, indeed. Raise your voice to the
Do
heavens.
you hear me?
Yes, yes, thank you.
Okay.
Flawless. All right, defense counsel, your witness.
Hello, would you please state your name for the record?
My name's Hazel Rossi Cole.
Do you know why you're here today, Miss Rossi?
Yes. Think so.
Do you recognize anybody in this courtroom as being connected to you in a prior matter?
Yeah.
Who?
Kelly Price Cutter.
And what is your prior experience with Officer Price Cutter?
She's arrested me a couple times.
The facts of the case before the court today, do they sound kind of familiar to you?
Yeah,
Why do they sound familiar?
because I also got charged for the same.
Could you say specifically which charge Ms. Price Cutter pursued against you that's the same here today?
Attempted first.
Thank you so much. Would that be aggravated attempted first degree murder?
Correct.
And what happened in that case?
It got dismissed.
Did it?
I got found not guilty.
Thank you.
What?
Thank you. I understand it was some time ago and that you're not a lawyer,
Wow.
so I understand, Miss Rossi. Thank you so much. Do you remember why the judge said that you were not guilty?
Because it wasn't premeditated.
And did you plan your attack in that case?
No.
But you did attack officers.
Yes.
And what was the state's argument that you had planned your attack?
That I staged myself.
Did you hear that argument made again today in court?
Yes.
Was that argument accurate?
Whose argument? Sorry.
Ms. Price, did Officer Price Cutter tell the truth about what happened during your encounter with her?
No.
What actually happened?
Our vehicle ended up crashing out completely, so there was nowhere for us to go, and we just never left the area.
And so how did you decide to attack officers?
What do you mean?
Well, so, you eventually attacked them.
Yeah.
How did you make that decision?
Because I was surrounded by officers,
And when did you make the decision?
right then and there.
But the state argued that you had a plan?
Yeah.
Does that sound like what happened today?
If it was planned?
Does the argument sound the same?
Oh, yes.
And are you aware of whether Ms. Price Cutter has pursued charges like this in the past?
I don't know about other ones, but mine, yeah.
Did she tell you why she charged you with aggravated attempted first?
To me personally, no, I don't think so.
But despite, never mind. Is there anything else you'd like to share with the court today? You don't have to. I just wanted to give you an opportunity.
Oh, I hope you find him not guilty.
Oh, okay. Thank you, Ms. Rossi. No further questions, Your Honor.
State, your witness for cross.
I have 2 questions, maybe it's just to get in there. I want to establish. She said we were surrounded and we had no other way out, and I just want to make sure that this is not the same in this case.
Well,
then,
they weren't surrounded.
Yeah,
I would
exactly.
say that's an inaccurate statement.
Mm-hmm. All right, sounds good. Anything else? Anything you want to?
Nobody was actively chasing her. She was waiting under a fucking overpass, armed with a knife in her hand.
I would not further argue that. I would just make sure that her case is not relevant to this case.
Oh, perfect. Go for it. I believe in you.
Sorry, Your Honor. Hello, Miss Ross.
Hello.
You stated in your testimony with the defense that in your case you were surrounded. Yeah.
Yeah.
Were you here for the entire court case?
For this one here?
Yes, for this one here.
Unfortunately.
Were these suspects in this court case that's currently on trial surrounded?
If they were surrounded by cops?
Yes, they were fully surrounded, had no way out.
Objection, Your Honor. Not she didn't testify about any of this. This is scope.
Sustained.
What does sustain mean?
That means you don't have to answer.
You don't have to answer that one. Yes.
You stated in your testimony with the defense that you were not aware of any other prior charges Miss Kelly Price brought. Is that correct?
Before mine, yeah.
Are you aware of CM 211 2025 CM 211?
I don't know what any of those numbers mean.
Your Honor, I didn't hear that citation.
2025 CM. What was it, Counsel?
211.
211.
Your Honor, could we get that in an email, like the way
It
that
would
I
be
did
preferred,
for?
yes. That could be sent to the court and opposing counsel, please.
Confirming receipt.
Done, Your Honor.
Yes, received. Thank you. Might be beneficial to send it to the witness as well, if you could.
Your Honor, we're going to object based on scope to this citation and line of questioning, both given that she didn't testify about it and that there's a plea of no contest.
Yes, I'm leaning that way, but I'll give you an opportunity to rebut this time.
Your Honor, the entire argument was that Kelly Price is pushing these charges unfairly, and the state would argue that how are they pushing them unfairly if there's a case where she agrees with the charge.
Your Honor, again,
I'm going to sustain that objection.
Thank you.
Mostly because that's somewhat of a mischaracterization of no contest. Proceed.
Thank you.
With another question, not that one, of course.
Yes, Your Honor. One moment to confirm. Really have anything else? And because he called them like 2 minutes before fucking trial, we don't have them on our witness list. So we also rested our case, so I don't really have anything.
No, I'm fine.
Do you have anything?
It doesn't bother me.
No. Nothing further, Your Honor.
Outstanding. Defense counsel, do you intend to
We
call this
thank and
witness?
excuse Ms. Rossi.
Thank you very much. Prosecuting counsel? Well, I can't, not that you can, actually. Outstanding. Defense counsel, your case?
We rest, Your Honor.
Flawless. Thank you very much. I presume the parties will need some time for closings.
No.
Not for the defense. Prosecution?
Are you ready on close?
The state will request like 10 minutes, please.
That's fine. Now, the court will make it clear that this will be a deferred ruling. There is an awful lot to comb through, approximately 3 hours worth. So, unfortunately, this will be a deferred ruling. However, court is in recess so that counsel can prepare their closing statements. Thank you very much. There it is, slightly delayed, much like my ruling.
It's just wait for Sand and Bonus State to take their.
Are you good on the closing? You need any help?
Oh my god! Oh my god! It's a terrorist attack! Oh my god! He just punched him like 10 times!
Matt, if this is not a terrorist attack, we're gonna have words. Excuse me, Daphne. Sorry.
DOJ going wild. Oh.
You know what? No, I said if anyone causes anything, put him in the hold. The hold's the other way. Yes, please. Excuse me.
Bad guys, we gotta rob a bank after this.
Yeah, that bank do be needing to be robbed.
Well, where this exactly?
Excuse me, I'm coming back. I'm coming. Excuse me. Excuse me.
Yeah.
What if I guaranteed your getaway?
Oh my god.
Okay.
All right. Layla.
Oh,
Layla.
hang on 1 second.
Who the hell did they just put in the hole? Why? You sure it was from PDO? Because PDO's sitting over there. No.
All right, the disturbance has been contained, everybody.
Thank you, Your Honor.
You're welcome.
I think, was it, are you sure it was a PDO, Lanny?
W containment. Whoa!
Because he did look like Jake Marks, and they did say, like, DOJ going wild, so I think it is him. already a report about it? No. I think it was Jake Max because he came in. Yeah, I absolutely get you. It's like, yeah, it feels like 4:30. And yeah, I mean, we tried to get through them, and he was busy like asking 7 times the same question.
What the hell?
What's this?
Like, on one point, I'm kind of miffed that I didn't get to
Another
ask
chemical attack.
freaking questions because of scope, and let him do whatever the fuck he wanted in scope. But again, that's on me. But I was just sitting here like, I am like, we already lost 45 minutes due to his stupid pretrial shit. I wasn't gonna waste another hour due to objection. Yeah, well, at least tomorrow is a bit earlier. That's cool. Honestly, as much as I want to do the trial, dude, motivation for these two matters have been pretty low for me. As much as it sucks for officers involved, I would not get restless nights over Rafael Messi dismissing it tomorrow. And given Raf, I feel like he's probably going to grant those matters. Yeah. I mean, if tomorrow is just like dismiss the first-degree murder charges and it's just the bank robbery, yeah, I'm down for that. That's not a big deal. Oh, you just get him on second degree, to be honest. I don't know if it's worth the headache to me. I mean, I'll be honest with you. Like, no matter how the outcome of this trial, we definitely won because we got CB off the street for like 4 hours.
Hey, Mr. Prosecutor, can you come with me a minute, please?
Yeah, true. Yeah. Mm-hmm. Yeah. Yeah, I agree.
What the hell?
I mean, even if the warrant is served on like first degree, we can just change it to second degree on the docket. That's not a big deal. Yeah, that is the big thing. Mhm. Yeah, but that's just kind of what he does. He just keeps re-asking the same question over and over until he gets the answer he wants. Yeah. Oh, until you go, I don't recall, and then he like huffs and puffs, and he's like, "Oh, you sure you don't recall?" you know, yeah, no, I get his defense arguments. They're definitely good. I don't hate him for his arguments. I don't hate him for him being a lawyer. I hate him for the slimy shit he pulled. Yeah. It's he's a slimy little bitch, ass kisser, and that's why I dislike him. Man has no spine.
All right, ladies and gentlemen, court is back in session.
Alrighty.
Are we all prepared to proceed with closing statements?
Are you ready to go? Status
Defense
prepared, Your Honor.
certainly is, Your Honor.
Fantastic. All right, prosecuting counsel, your closing, please. Thank you very much, Counsel. Defense, when you're ready.
You did good. You did good.
Your Honor,
I
your
probably
decision
would've-
is easy today because the state has admitted
Probably would have brought up
that
crime
Mr.
crisis.
Ward did not engage in this conduct in a premeditated, deliberate, planned, and targeted manner. The state, in fact, just said in its closing statement that it's entirely possible, there's reasonable doubt that Mr. Ward may not have, taken that premeditated step. There's any number of reasons, any number of possible outcomes, in fact, that could have occurred based on the events that
I
happened
do
here.
hope they know crime crisis.
It
otherwise
was
it's
not
gonna be a
necessarily a given that the individuals would step out of the car with shotguns. It was not necessarily a given that Mr. Ward would participate in the attack against officers. It was not necessarily a given that an attack against officers would happen at all. Instead, what actually happened here is that officers made repeated and ongoing attempts to apprehend Mr. Ward and others, and the court heard today about those different attempts and how Mr. Ward and his efforts to escape were mitigated. In fact, the officers are to be commended for their efforts to apprehend alleged criminals, as is their job, but for the fact that they, lost a shootout. And what's happened here today is they're upset that they lost. And now they're upset that they're going to lose in court, which is why His Honor saw an effort to amend the charges before the court at the last minute before the case happened. In fact, the effort to amend was after His Honor's discovery deadline. Now, that effort was not pursued today, but it is relevant to the court's consideration of whether the prosecution understands what evidence is before the court and what they can and can't prove. And as a matter of law and precedent in this state, the prosecution has completely avoided and in fact misrepresented what has been held as being the requirement to prove aggravated attempted first-degree murder in this state. For example, this court has ruled that for the planning element to be satisfied, there must be some sort of separation from the time a plan was made and the action was carried out. Examples were given of what that separation could be, including, but not limited to, a distance in time, physical space, or emotional state. And in some circumstances, the court found there would need to be a combination. Here, however, as in the quoted case of 2025 AC 015, there was no premeditation, there was no planning, there was no targeting, and it certainly wasn't deliberate. There's no dispute that Mr. Ward was present on scene. There's no dispute that he brought a screwdriver to a gunfight. What you did here today was varying testimony from officers about whether they believe
Your
these
Honor. We would argue assumes facts on an evidence not been established what weapon Mr. Ward had, and if it was a screwdriver on.
It was a screwdriver. I stabbed 2 cops with a screwdriver.
Mr. Ward, I'd ask you to be silent just so that way we're in the clear.
Your Honor, he stabbed 2
Counsel.
cops with a screwdriver. I also believe that objecting to closing statements is procedurally improper and would ask His Honor to overrule the objection and allow me to continue.
The objection will be overruled, but assumes facts not in evidence is indeed a valid objection to raise during the course of a closing statement as per previous case law. So that is permitted practice. However, it will be overruled on the basis that it was a matter which was in dispute as per the testimony of Layla Diaz. So that will be overruled.
Thank you so much, Your Honor. I apologize as my tempo has been interrupted, so you'll just have to give me one moment.
Of course, not a problem, Councillor.
The statute at issue requires that the state prove that the conduct was deliberate, planned, and targeted. Each of these elements must be proven. The state has alleged that they have occurred. The state has said that they were possible. The state has said that these things happened. But the state has not proven the intentions of Mr. Ward beyond a reasonable doubt. Witnesses on the stand today admitted that there were possible other alternatives, possible other motives, possible other circumstances, and indeed that they would not bring a screwdriver, or a knife, for that matter, to a gunfight. The court has been presented with what is certainly a set of tragic events for the officers involved. But Mr. Ward doesn't actually deny, and in fact offered in the cells to plead to aggravated attempted second-degree murder 6 times. The state knows this. It's why they sought to amend the charges, and they know that those are the appropriate charges. Here today, despite their best efforts, and despite the ongoing crusade of Miss Officer Kelly Price Cutter herself to pursue inappropriate charges in multiple cases, the only evidence or example proffered to the court today was a case where the individuals at issue pled no contest, perhaps because they didn't want to deal with court, perhaps because they knew they had done it, but most importantly, as the court rightly found, that plea is not evidence that the charges were appropriate. It can't be taken as such. In court today, the state had the burden of proving beyond a reasonable doubt each element of the offense as it relates to Mr. Ward and the circumstances more broadly. Instead, what you heard is that there was a haphazard set of circumstances slapped together at the last minute that endangered the individuals engaging in the violence, not just the officers at issue. Because one of the individuals was injured, they were running from officers, they got caught up to, and they couldn't make it to the car before the officers started potentially capturing them. So their buddies came down the stairwell and allegedly shot. Now, if the court finds that this is attempted first-degree murder, then perhaps everything is attempted first-degree murder, anytime that there is attempted murder at all.
Oh yeah.
That was surely not the intent of the legislature.
If this is
It
found
surely was
guilty,
not the
then
intent of
court
prior
system is
judges who have
ruined.
heard similar cases, and it is surely not the binding precedent that this court is subjected to today to uphold as a district court. We appreciate greatly the court's time and that of the witnesses and individuals who have chosen to be here to listen to Mr. Ward's story and that of the officers involved. And we certainly are sympathetic to the officers that the result today may or may not be what they're looking for. But if the court finds in favor of the state in this matter, well, it may have unintended consequences. Incentives matter. Belief in a functioning justice system matters. And if people believe that seeking their day in court will not get them the justice they believe they deserve, and in fact do deserve as a matter of their constitutional rights, I fear what could happen to our fair state. Thank you so much for your time, and have a wonderful evening.
Thank you very much, Councillor Murdoch.
No,
as I
this is
stated,
our part is done. And
earlier,
I would assume
this
Blackstone
court
and
will be
Winnie are
giving a
aware of the
deferred
crime
ruling on
price.
this matter just because it is rather late, some might say. I would like to, of course, take this opportunity to thank both sets of counsel, the defendant, and all the people in the gallery. I've got to say, despite one or two hiccups, the conduct here has been exemplary, particularly by counsel. I do appreciate the efforts of counsel to try and speed this up a little bit. Granted, it was 4 hours, but efforts were made, and that is what matters. And the court does absolutely appreciate that from counsel. This, of course, is going to be a highly complicated matter, and to rule on, that is, and the court may take some time in deliberating on this matter. In such circumstances, the court would ask whether counsel for the defense or counsel for the prosecution, well, obviously not the defense as much, but the prosecution, as to whether the defendant has breached their bail.
No, are you sure?
To the court's understanding, there is no breach of bail.
Are you 100%? We are not aware of any breach of bail either.
Outstanding. In that case, given that
Your Honor, it's Mr. Marcus's position that he was the best bail boy that a bail boy could be.
Perfect. The court would be in agreement with you, Mr. Ward. Yes. So this court will be ordering the release of the bail conditions upon which Mr. Ward is subject to, given that we are, of course, going into a deferred ruling, and Mr. Ward is entitled to having his bail monies returned via asset return. This, of course, regardless of circumstance on ruling, and council will, apologies, the court will issue directions in respect of this matter moving forward for the defendant. That does conclude this hearing. Is there anything further from either party?
Shall we mention the crime crisis or no?
Sure, go ahead.
Nothing from us, Your Honor. I was waiting for the state, but it sounds like they don't have anything either. The only thing we were going to have was the release of bail. So thank you so much for doing that proactively.
Not a problem. Yes, not a problem.
The state would only assert, as the court I'm sure is aware, that this would fall under the Crime Crisis Act.
Yeah, that was, it did catch our mind, but that you know, we won't consider that something that was brought up now. Of course, we will. It was brought up during the course of the proceeding, or was inferred in any event. So we're quite happy with that. Nothing further, I presume, prosecuting counsel.
Do you know about when your ruling will be posted?
I do not, but I am hoping within the next 24 hours, but it may be 48 hours. I envisage tomorrow I may have a bit of a lie in this regard. So forgive me if there is.
Your Honor, out of curiosity, any chance you're going to have it ready before 4 p.m. Eastern tomorrow?
That is likely, yes.
All right, word.
Given that would be approximate, it feels like it would be about 9 p.m. for me. That is likely, yes.
Do you understand? Does His Honor understand why we're asking? Like the state cares also for the same reason.
I do.
Yes, Your Honor, we do.
Yes, I will make best endeavors to do so. I hope it will be, but it is one of these things, unfortunately.
Weird how he cares about it, given that he argued the cases were fundamentally different.
Thank you very much, counsel. This court is adjourned. Thank you again.
It's very true. So crazy.
So crazy.
I did teach you how to do that. That's so true.
Marky Boy's a free man.
He did it. He did it, but I didn't.
For now.
However that worked.
Crazy. It's crazy to me how he like argued on the docket that these were wildly separate cases and should be trialed differently and not merged. And now he's like, oh, but can we get the ruling before the other case so I can use it in that argument?
Don't do that now.
God damn
I was
it.
going
Like,
to check with Winnie that she's going to be okay from here. I was made aware of some threats made to her, so I'm just going to make sure that she's going to be good leaving here.
Oh my gosh.
Before I head off. Yeah.
Is she okay? Where's she at?
She's just over there. I'm just going to make sure
she's
she's
just
going to
over
be good
there
leaving.
with Well, same thing tomorrow, I guess.
I look forward to it.
You know, I honestly, I have no idea. What the fuck did you...
Muscle spasms. He was in there for the protection of the gallery. Not, he's not being charged with anything.
Okay.
You believe
Okay,
I'm
but-
I'm so influential
Oh, you're a terrorist?
and I pursue.
You're terror.
Yeah, I'm a terrorist. I'm terrorizing the poor
Yeah.
individuals in the state.
The poor
by charging
criminal.
them with the crimes that they commit.
I did catch that part before I had left, and a couple times since
Yeah,
I've been back.
men, absolute men.
I believe he used that argument before.
I feel like his thing is to argue aspects of the case that aren't actually.
Good night.
Why does that
everyone.
attorney keep beating people up?
Jake, will you stop beating the Department of Corrections?
Sorry, guys. Okay.
The court's already shown you mercy once.
Yeah. Walk me to the door, Elias. Guys, bye, guys.
Bye, guys.
Bye.
Thank you,
We're
everyone
going-
who
oh,
showed
shit.
up. I appreciate you very much.
KP, I'm going to go with Winnie.
Alright, I'm gonna leave too. I'm gonna go to my car.
Who
Who's
stole
sitting
your
here?
hat?
People littering,
Gremlins.
Oh,
taking out.
Gremlin? Oh my god.
I don't.
sounds about right.
The mouse of the court and snap.
Officially closed.
Yay!
Oh my
Great.
God, I've been assaulted twice in one.
Sometimes it will be like that, you know.
That's crazy.
That's okay.
Honestly, at this point, just shoot me.
No,
They're
thank
gonna
you.
be less likely to bother you if I'm here.
I don't give a fuck at this point. Willow, I gotta be honest.
Well, I care if you. No one should get shot. I don't care who they are.
I would agree. I don't like shooting people.
I think that's your
I can't wait to
ex-boyfriend,
do the
Kelly.
exact same case tomorrow.
What do you mean?
On the bike.
I can.
Oh, well, good for him. Surprised they didn't call him as a witness.
Oh, let's not run over the judges and cops. That would be bad.
I'm sure it'll be fine.
Please don't.
It's only Winifred Baker.
I'm gonna chill for a little bit, then I'm going to sleep.
Perfect.
Had a long day.
Alright. Perfect. You guys stay safe, okay? Bye.
Oh my god, those officers did not help my case at all.
2 hours ago, I said I was only gonna stick around for like 2 hours. I stuck around 4 hours. We lost 45 minutes because Matt Murdank decided to do like 12 fucking motions to dismiss, and all of them, like the. And then he was like,
Be prepared for those same motions tomorrow.
Yeah, I know. And then he was like, you're not gonna have this on record. Can we? He argued that like the trial should be dismissed because statute of limitation.
What's up with that local? Am I still muted? No, I'm muted. I probably left myself muted for my closing. Oops. Don't worry, there'll be opportunity to hear the same exact closing statement tomorrow.
You know what? We should throw back a few longer.
I guess I don't know how to argue premeditated if we don't win this. I don't think it's possible. They could literally have a plan written out and say, you be here and you be there, and we could get that plan, and probably, according to Matt Murdank, it still would not be aggravated attempted first. Don't rate me, I gotta go to sleep. I'm going to beddy bye. We're gonna pass it on. Have an above average night and a sunny day, sir. I guess I'll see you tomorrow. Same case, same arguments. It'll be a lot of fun. Let me see. Let me find somebody to pass it on. Let's call Raiden. Who is around? This one is still open. I gotta... Oh, it wasn't open. Who can we raid? Let's go raid Flashy Unit. We'll go see some police shit. They were hanging out. They were watching. I hope it was a interesting case, at least. Have an above average night. Have a sunny day. And, go watch some different police shit. Over here with Mr. Flash. Night.